May I please your lordship, my lord? So in item number 59, my lord may not like to take up this matter.
59.
Lordship.
Okay.
Supplementary item.
List the case for any other future.
Pending matter, my lord, allotment of land, my lord. District level land advisory committee already, my lord, selected, but cabinet decision has not, my lord, taken, my lord.
Admission. Admission.
31st.
Give it to the court master.
May it please your lordship. With an apology, madam. This complete waterlogging in my chambers area. I could suddenly come, but I have no files. 2 and 14. Could you be taken up next week?
Okay. On the
Except 29.
request of Mr. F. Boni, Senior Counsel, bring for the petitioner. List the case on. When do you want?
29. Except 29. Any day.
Okay. Side you.
Lordship.
And next is
2 and 14.
14.
14.
Okay.
We'll file the affidavit also.
3rd August.
Obliged.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 51 of the daily list, my lord. My lord, the matter hearing, my lord, we have not received our instructions, my lord. Awaited, my lord.
Who is for the petitioner?
I am.
Mr. F. Aforesaid, Learned Counsel for the petitioner is present. Mr. H. Borua, Learned Standing Counsel, Learned Counsel on behalf of Mr. B. Gogoi. Learned Standing Counsel, Finance and Taxation Department has submitted that the instructions are yet to be received to file counter affidavits and has thus prayed for further. How much time you need?
2 weeks, my lord.
Further 2 weeks time to obtain the instruction to file the counter affidavit. A prior law lays the case on submission.
10th August. 10/08.
May please, my lord, with consent from the NC Hills, my lord, I beg to mention item number 58, my supplementary. My lord, they have filed a affidavit in opposition. I want to file reply. 2 weeks time may be granted.
Mr. B. Borua, Learned Counsel for the petitioner, has sought for and is granted 2 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent AAAC.
NC Hills.
Oh, and NC Hills Autonomous Council. Post raise the case, the praise made with the consent of the Learned Counsel for the respondents. Lays the case on concerns.
Can a date be given? My lord?
12th August.
Interim order, my lord, earlier interim.
Interim order, it passed earlier, shall continue till the next date of this.
12/08.
May it please, lordship, with the consent of the other side, my lord, beg to mention item number 49, my lord. Chairman, respondent has filed the affidavit in opposition on Friday, my lord. I'm paying for 2 weeks time to allow file my reply, my lord.
Mr. R.S. Pistol and counsel has Learned Counsel for the petitioner has sought for and is granted 4 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondents. Place the case after 4 weeks on affidavit by the office. Any interim order?
Yes, there is an interim order, my lord.
Interim order, if any, passed earlier should continue to next date of this.
Much obliged.
May I please, sir?
H. Borua, Learned Counsel on behalf of the respondent, Finance and Taxation Department authorities is present.
I beg to mention item number 11, Your Honor. Kindly pass over the matter for the day, and this matter may be come up next to any date, Your Honor.
On the request of Mr.
Eh.
Learned Counsel for the petitioner, the case is passed over for the day.
May it please, lordship, I'm praying for listing of motion matter. If lordship permits, can be tomorrow. Police has held my vehicle, my lord, at Chaglia outpost, my lord. They have not issued a detention order, my lord. Sometimes they
Wednesday.
much obliged.
May it please your lordship. Lordship, I beg to mention item number 1, lordship. Lordship, I am seeking adjournment, lordship, as the senior counsel is out of station.
On the request of
Ms. J. Bezbora, lordship.
D. Besboro.
J.
The case is passed over for the day.
Your lordship, I beg
Petition.
to mention item
Petitioner.
43. Your lordship, is a joint prayer. The petitioners has filed their reply on Saturday. And your lordship, the conducting counsel KP Pathak is not here due to some medical emergency.
Case 43.
Item,
Item 43.
yeah, item 40.
Yes. You are for
For
whom?
respondent,
Respondent. Respondent which one? APDCL.
KPDCL 1, 2, and 4.
Okay. Your name please?
S. Borwa,
As Borua. On behalf of?
KP Pathak.
Ms. S. Borwell and counsel on behalf of Mr. K.P. Pathak, Learned Standing Counsel, APDC, has made a prayer for adjournment on the ground that Mr. Pathak has personally difficulty.
I for
Prayer is made
I for
from Mr. N. Goswami, Learned Junior Government Advocate for response number 2 is present. So it is submitted that counsel has been taken from the counsel for the petition to make the prayer. The prayer is allowed, release the case after 2 weeks and 2 weeks by the office.
May I please, Lordship? Lordship, I beg to mention item number 3. In this matter, some typographical error is there. So amendment may be allowed, my lord, and some
Amendment
amendment of the petition is required, my lord.
under Mr.
N.M. Azarbuya on behalf of Mr. S.A. Wasi.
I sought for adjournment of the case for 2 weeks. Prayer is allowed. Release the case after 2 weeks. So I did 2 weeks by the office.
My lord, there is another prayer. In item number 23, that matter may be kindly adjourned for the day due to some
Okay.
difficulties of the
Mr.
council.
Learned counsel on behalf of S.A. Wasi, Learned counsel for the petitioner. The case is passed over for the day. It is submitted that counsel has been taken from the Learned counsel for the respondents to make a prayer.
Grateful, my lord.
Lordship, I beg to mention item number 47, Lordship. Lordship, my senior is not present today, Lordship. Lordship, may fix the matter on next week, Lordship.
Your good name?
A.R. Mondal.
Learned A.R. Mondal, Learned counsel for the petition and the prayer of Mr. French. The case stands adjourned for 1 week. Submitted consent has been taken. Huh? You have informed the other sides?
No, Lordship.
No. Then they will wait up to item 47.
Lordship will inform. We tried, Lordship, but could not reach.
Consent.
Hello.
May I please have Lordship, I beg to mention item number 42 for adjournment.
42.
42.
Okay, you are for which side?
Petition M.K. Mishra.
Yes. How much time?
Lordship, 1 week or 2.
Miss
B. Sinha.
B. Sinha. Learned counsel. Appearing on behalf of Mr. M.K. Mishra, Learned counsel for the petitioner, has made a prayer for adjournment. It is submitted. You have informed the other sides.
Yes, we have informed.
Okay, it is submitted that consent has been taken from the Learned counsel for the respondents to make a prayer. As sought for, place the case after 2 weeks and 2 weeks by the office.
May I please, Your Lordship? Lordship, I beg to mention for a listing of a writ petition, Your Lordship. It's a land matter.
New writ petition or old writ petition?
Sorry, Lordship.
New writ petition or pending writ petition?
Pending writ petition, it's in the motion stage, Your Lordship.
Give it to the
For withdrawal, Your Lordship.
huh?
For withdrawal,
Withdrawal. Tomorrow?
tomorrow. Obliged.
My lord, so for item number 42, the petitioner takes time. My lord, date may be fixed only, my lord. 42, already took time, my lord.
Vivo August last of it.
Date, only date may be.
August last of. Yes.
Hi, Lord. 19th August. 1908. Daily list for motion. Item number 4. Item 4. We see.
बस फीडर करना है ऑब्जर्व ऐसी हुई है
Pass over for it. Itu kuisa itu.
নাই কোনো? Going further. This contempt petition is preferred, is filed alleging willful and deliberate violation and stroke or non-compliance of an order dated 24/6/2025, passed in a writ petition, WPC number 2633/2025. Para. As per the case projected, the petitioner is the registered owner of a commercial vehicle bearing registration number NL01/AZ 2858. Subject vehicle for short postal. The petitioner had availed loan facility to the extent of rupees 38,50,000 from the respondent from Tata Motor Finance Limited on 11/11/2022, which was to be paid in 47 equated monthly installments, EMIs, from 11/11/2022 to 11/9/2026. According to the petitioner, he had already paid a sum of rupees 19,87,416 towards the loan account on the date of filing the contempt petition. As per the account statement dated 14/2/2025, the outstanding amounts under the loan account was rupees 26,78,390, and the overdue installment amount was rupees 6,90,970. Para. The petitioner apprehending illegal repossession of the subject vehicles. The petitioner approached this court by the read petition, WBC number 2633/2025. Post. On the read petition was moved on 24/6/2025, comma, the court, comma, as an interim measure, comma, directed the petitioner to deposit an amount of rupees 1,50,000 within a period of 15 days from 24/6/2025, and another amount of rupees 1,50,000 within a period of 15 days from the date of deposit of the first installment of rupees 1,50,000. The court, while ordering listing of the case on 24/8/2025, comma, observed that till the next date of listing, comma, the respondent Tata Motor Finance Limited shall not repossess or seize the subject vehicle subject to compliance or the direction to deposit the said amount of rupees 3 lakh in total by the petitioner within the stipulated time period. Para is the case of the petitioner that the petitioner deposited a sum, an amount of rupees 1,50,000 on 3/7/2025, and thereafter, comma, completed payment of rupees 1,50,000 on 30/11/2025. Post. Subsequently, the petitioner deposited amounts of rupees 50,000 on 31/12/2025, rupees 50,000 on 31/1/2026, and rupees 30,000 on 31/3/2026. Post. It is stated that subsequent to the order dated 24/6/2025, comma, the petitioner paid an aggregate amount of rupees 4,30,000 towards the loan account. Post. Para. The petitioner has alleged on Eight 5/2026. The subject vehicle was has been illegally and forcibly seized. Post. Which such assertion, the contempt petition is filed. Yeah, the WBC. So, WBC number 2633/2025, subsequent order की रखी है. Agree, I guess. Draft petition. has not mentioned. It is not stated by the petitioner that whether after 24/6/2025, the interim order has been extended on the subsequent dates of listing. Those as the learned counsel for the petitioner is found absent today on call. Let the case be listed again on. Yes, Mr. Counsel.
May I please allow? No, it's a content petition item number 4.
Yes. Your case is that on your case is that on 8/5/2026.
In this matter, my paper.
Your case is that on 8/5/2026,
Please allow.
the vehicle has been seized.
Yes, Your Lordship. Please allow. And that is in violation of an order passed by this honorable court, Your Lordship.
But on 28/2025, that interim
Please,
order
Your
has not
Lordship.
been extended.
Your Lordship, unless it is not specifically said that it is not extended, it would continue to operate.
Show us some
It cannot be
authority.
an automatic.
Show us some authority.
I'll assist Your Lordship on this. Some time be given. Let some time be given. I'll assist Your Lordship on this.
Mr. Your name, please.
I'm Karan Bharatwaj, Your Lordship.
A.
Karan Bharatwaj, Your Lordship.
Or it was
K. Bharatwaj.
who is appeared learned counsel for the petitioner who has appeared to virtual mode, to the virtual mode. Kama has sought for listing of the case on another date. Leave the case on such.
31st July,
Yes,
3107.
Please, Your Lordship.
Item 5.
Please, Your Lordship. This contempt case is relating to non-payment of victim compensation as my husband has been murdered. This honorable court passed order dated 19 February 2026, page number 10, operative portion. Para 4, page number 10.
District Legal Service Authority has passed any award?
No, Lordship.
Heard Mr.
Ardeka.
Article and counsel for the petition. This contempt petition is filed alleging non-compliance of the direction made in an order dated 13/2/2026, passed in a repetition WBC number 733/2026. Post of it is ever that the order dated 13/2/2026 was duly brought to the notice of the respondents. Post of issue notice returnable. So it's returnable in 4 weeks. A petition shall take steps for service of notice upon the respondent by speed post within 2 working days.
Item 6.
This is also similar order, Lordship. Two brothers has been murdered in this case.
Order dated 13/2/2026. WBC 753/2026.
Page number 10, Lordship.
Same.
Obliged.
Item 7.
Yes.
Please, my. The dispute regarding the compensation award, my lord.
Hmm?
Dispute regarding the compensation award, my lord, for the acquisition of my land, my lord, for construction of the National Highway 17. My lord, the amount was disbursed, my lord, but to the wrong person, my lord. Respondent number 8, my lord.
Okay, award amount was deposited.
That was deposited, my lord.
Oh, yes. Then what happened?
My lord, it was deposited in the account of the respondent number 8, my lord.
No, deposited according to page 18, some National Highways Act.
Yes, some given some NOC Lordship.
Under section 3H2.
Yes.
Yes, thereafter what happened after page 18?
My lord, what had happened is that, my lord, the respondent number 8, my lord, he had forcefully abducted me, my lord. And under coercion, my lord, he had told me to
Forcefully
abducted me, my lord. Take a constable.
abducted.
Abducted me.
Abducted. It is a criminal offense.
Criminal.
So have you filed any FIR?
My lord, FIR went, my lord, before the Sapori PS, but they didn't register. That is why I approached the honorable DGP, my lord. I have filed one representation. Till that has also not been considered.
So that is after under 156(3) or 175(4) BNSS
My lord,
for registration of FIR.
that is.
That is your remedy, judicial remedy. Then what happened?
My lord, in this case,
So on behalf of promotions. You have issued a no objection certificate.
Yes.
Lord, that was under coercion.
Right,
Yes,
right.
Yes,
But
ma'am.
there is a record
Yes, ma'am.
which is identified by an advocate
Yes,
and before a notary.
Yes.
yes, ma'am.
Before a notary.
Yes.
My lord,
That was on which date?
my lord,
26/7/24.
24.
26/7/2024.
Yes.
Page 26, lordship.
Huh?
27.
I have read because that is LTI of both the parties. And there is an identification by advocate
Yes, ma'am.
and plus it was notarized,
Yes, my lord.
right?
Yes,
So if there is a presumption, then when did you object?
my lord.
When you were released from being abducted, after
My lord,
abduction?
After this, my lord, after,
After when? When
lord,
you were abducted?
my lord, when the.
On which date you were abducted?
Exact date I don't have, my lord.
Huh?
My lord, after the.
Which date?
Date?
There must be a date of abduction
Yes, my lord.
and date of release also.
He was kidnapped
My
on
lord,
15/7/7.
15/7/24, my lord.
15/7/24.
22, my lord.
15/7,
24. And
Page
page
32.
15/7/2024, page
32.
in
page
the petition also.
32,
In his petition also, page 7, paragraph 5.
page 7, okay, para 5,
Second paragraph.
page 7, para 5,
Second paragraph.
second paragraph. And you were released?
My lord, release date, my lord.
Huh?
Release date I don't have, my lord. I can ask for it, my lord.
No, we don't ask for.
No, no, my lord, I can.
We don't ask for that. Then when did you complain about?
My lord, my lord.
So it goes to show page 28 that from 15/7/2024
Yes, ma'am.
to 30
June.
23rd June 2025,
Yes.
for a period of about 1 year, you were under confinement. If the date is not mentioned.
My lord, here, my lord, may kindly have.
Is it a case for writ petition?
My lord,
Uh.
my lord, I am on just one point, my lord. My lord.
Yes, your 1 point, yes.
Just one point. The section 3H, which my lord had pointed out sometime back. If I may read, my lord. That says, my lord, as soon as maybe after the amount has been deposited under subsection 1, the competent authority shall on behalf of the central government pay the amount to the person or persons entitled thereto. Now, my lord, person I was, my lord, because in the LA notice, my name is there. Mr. Ismail Hawk's name is not there, the respondent number 8. My lord, the authority should have also done some due verification, my lord. My lord, I understand my NOC is there, my lord. It is an admitted position. But my lord, before
No,
this.
but your reaction
Yes.
after that,
Yes, my lord.
after this, your abductions and so-called abduction,
Yes.
and thereafter this execution of this NOC
Yes.
on 26/7/2024.
Yes.
And about your late reaction on 23rd June 2025, that cast some kind of doubt on the veracity of the version of the petitioner.
My lord.
And thereafter, waiting for 1 year more to institute this writ petition, that adds more doubt to your case.
My lord, I found the date which my lord had posed, my lord. It's 7/5/25 when I was released, my lord. From when I came out of his clutches, my lord.
7/5/2025.
It is
Oh, 1 year.
Yes.
Okay,
As per
very
the
good.
presentation.
1 year. 1 year.
My lord,
Okay, we'll record that.
it is there in the representation. Page 30.
Tell me, okay. Heard Mr. P.R. Sharma, Learned Counsel for the petitioner. Mr. N. Goswami, Learned Junior Government Advocate Assam, for the response number 1.
4, 5, 6, 7.
4, 5, 6,
and 7.
7. Mr. A. Aforesaid, Learned Standing Council, Revenue Department, for the respondent number 2. First, para. A plot of land measuring 2 bighas, 2 kathas, 0.03.39 lasa, covered by tag number 884 and patta number 113, situate at village Hardemara, Hardemara, Sapor Revenue Circle, District Dhubri, subject plot, was acquired by the central government under the provisions of the National Highways Act 1956. Post or belonging to the petition. Subject provision. For construction of National Highway number 17. Post after assessment, and award number 70, assessing a compensation amount of rupees 23,93,987.86 was passed, and on passing of the award, award amount was deposited by the central government with the competent authority, land acquisition, Kala, as per the provisions of section 3H1 of the National Highway Act. First of the possession of the subject plot was to be taken on 21/5/2024, and in that connection, a notice was issued to the petitioner to make an application to receive the award amount. Notice dated notice 18/5/2024. So, it is the case of the petitioner that the petitioner was abducted on 15/7/2024 and was in confinement till
My lord, 7/5/25.
7/5/2025. The petitioner has stated that after being abducted, she was made to sign a no objection certificate to the effect that she had no objection if an amount of rupees 23,46,819 was paid to the respondent number 8. Post. The petitioner has alleged that on the basis of the said NOC, which was shown to be executed on 26/7/2024, the respondent number 8 had executed an indemnity bond on 26/7/2024 and deposited it before the Kala for disbursement of the said amount of rupees 23,46,819 out of the award amount of rupees 23,93,987.86. Post-op. The petitioner stated that after being released from confinement, the petition on
My lord, confinement on my lord, 7/5/25.
7/5/2025, the petitioner submitted a representation on 23/6/2025 before the Chief Minister Assam and the respondent number
EGP, my
6 on 23/6/2025. Post-op. Where have you stated that the amount has been disbursed already?
my lord, it is there, my lord. I made an.
During,
affidavit.
if the petitioner has further stated that during her period of confinement after abduction, the Kala has disbursed the amount of rupees
Six.
23,46,819 in favor of the respondent number 8. Post-op. Mr. Goswami and Mr. Aforesaid have pointed out that in the NOC, annexed to the writ petition as annexer 5, in the NOC. The NOC, in the NOC. Oh, sorry, the NOC, next to the one. So board, the signatures of the LTI, RTI, of the petitioner, RTIs, RTI of the petitioner, and the LTI of the respondent number 8. First off, they were identified by the concerned advocate, and moreover, the NOC is found to be notarized. Matter would require further consideration, issue notice, returnable on steps, as Mr. Goswami so-and-so. Authorized so-and-so. No formal notice need to be issued. The petitioner shall take steps for service of notice. Petitioner shall serve take steps for service of notice. When the respondent number 3 and the respondent number 8 by speed post it work.
21st August, 2108. Item 8.
Notice, right?
Wait, please. So this is the petitioner's land served brought under the Samala Road project. My lord. And this.
How many petitioners?
There are 6 petitioners.
6 petitioners.
Yes.
Yes, what went?
Now,
What
my
is their
lord,
case? What is their case?
the land of the petitioners my lord, are brought under the Assamala Road project, initiated in the district of Dima Assam. Now, what happened, my lord, in paragraph 4, I've stated in May 2026.
Paragraph 4.
Paragraph 4, my lord. In May 2026, second phase of art cutting has been initiated in large scale.
Paragraph 4.
Yes, Lord. In second phase.
So first phase, it is complete.
First phase complete. Second phase, my lord, they have to do the re-verification as per the notification, my lord. Notification of the PWD 20 January 2021. That assessment verification has to be, my lord, measured and mapped. That we have not been informed till now, my lord, and our contention, my lord, these are not done as per the notification.
What is the notification? Where is that notification?
Page 121, my lord.
121.
21, my lord. Notification dated 22nd January 2021. It's basically for Assam Malaman. Clause 4.3 onwards, page 123.
Page
123, 4.3, 4.4, and 4.7, my lord. 4.7,
4.7.
my lord. That has to be done by committee, my lord.
On 10 June, you submitted that they have already initiated process.
That is the thing, my lord. They have submitted one wrong information, my lord. After that, we've submitted one application. Now they have, my lord, issued another notice. My lord. That I think my learned friend will show.
Lordship, as a petitioner has filed a representation, which is at page number 167, of praying for re-verification.
167.
167. Operative portion is at page number 169, Lordship, where they have prayed for re-verification. And as per the representation, we have initiated a survey, Lordship, and we have also submitted report on that basis, Lordship, today. We have submitted the report, Lordship.
You have submitted the
Submitted,
report.
Lordship. After initiation of the re-verification, Lordship.
That is not brought on record, man, by FEDB.
You directed for verification of the claim of the petitioner by spot inquiry.
Lordship.
As per a letter placed here on 6 June 2026.
Lordship.
That was
And you were supposed to make spot verification on 9 June 2026 and to submit a joint report.
Lordship. And that joint verification report we have submitted now, Lordship.
Where?
Today we have placed, Lordship.
According to the report, so far as petition number 1 is concerned, some 8 lesser,
Has been acquired, Lordship, and
so bill is prepared.
prepared.
So far,
They are pre-
other petitioners are concerned, there is nothing,
No, Lordship.
no further.
So far.
We should notice that. Only petition number 1, 8 lesser, they have found.
Well, I will respond to it. my lord.
You will respond,
Yeah.
but it cannot be said that.
But your lordship will appreciate one thing. First notice when they have shown the earlier order, my lord, they have not done anything. Then second notice I have given just now, my lord. After 1 month, my lord, this thing has been done, my lord. Kindly see the
So far, petition number 1, they have found something,
and
8 lessers.
petitioner 4 also I took.
Petitioner 3, Lordship. Some
Three.
Compensation already paid.
No,
That
But
is your,
he-
that is your remark.
petitioner number 3, Lordship. For
Petition number 2, there is no land acquisition.
no land acquisition, Lordship.
three some there.
3, 400
Ah,
no,
but,
sir, betel nut
But 400 number of betel nut trees
Yes.
affected.
affected.
There must be some compensation.
Some convention. The determination is on process.
Alright, sir. File your reply. Art Mr. B. Borua, Learned Counsel for the petitioners. And Mr. J. Thousand,
D1000, Lordship.
D1000.
D1000.
PWD, Mr.
For PWD, I'm appearing on behalf of the
You are standing counsel PWD.
I'm appearing on behalf of the
Dinath, what is your good name?
R. Sahama.
R.
Sahama.
Saha,
Sahama.
spelling.
SAHIINII.
Please. Huh? On behalf of Mr. Dinath, standing counsel. Public Works Department for the response number 1,
1, 8, and 9.
1, 8, and 9, and Mr. D1000. Learned Standing Council, Dima Hassa Autonomous Council for the response number 3, 4, 5,
Lordship,
6, and Mr. 7, District Commissioner J. Hendy, Learned Junior Government Advocate for the response number 7. All are covered. The petitioners, 5 in number, have stated that they are permanent inhabitants of they have stated that in the first place for what is the road, where is the location?
My lord, paragraph 5, my lord. Paragraph 5 have given the everything, my lord.
Why
Page
not
10.
in synopsis?
Upstairs. Page 10, my lord.
There is no point in preparing the synopsis,
I have prepared, my lord, but this.
vague synopsis. No location, Dima Hassa District, Assam Malla project.
Paragraph 5. my lord.
লিখিবলৈ Okay. It is like, have stated that in the first place of the 2-lane of a road project, the petitioners were paid compensation under the road project, under the Assam Mala project, the petitioner were paid compensation. So, however, the respondent authorities have initiated the second phase of the project, and during the second phase of the project, the petitioners land properties have been sought to be brought under the purview of acquisition, full stop, without any verification process, full stop. Para, Mr. Housen, Learned Council, Standing Council, Limasa Autonomous Council has submitted that on receipt of a representation from the petitioners, a re-verification process and a re-survey was directed. Resurvey to field spot visit was directed on 6/6/2026. Was directed on 6/6/2026 for a spot verification on 9/6/2026. And verification team submitted a joint verification report on 7/7/2026. So Mr. Thompson has submitted that from the joint verification report, it transfers joint verification report. 18/7. On the joint verification report, it transpires that the lands belonging to all the petitioners are not going to be affected in the second phase of the Assam Mala project. First of, he has submitted that he likes to bring the findings of the joint verification report by way of an affidavit. And for that purpose, he has sought for listing of the case after 3 weeks. First of, let notice be issued. Notice is made returnable in 3 weeks, as Mr. So and so. No formal notice, extra copies will into working this component. The name of the government advocate Assam to be reflected in the respondent side.
I beg apology. Item number 7, I will collect that's why my NSA DCL from TM. My name may be so.
Okay, try to tell Harry Kodibo. 7 of C Bolua.
Item number 3, NSA DCL.
C Bolua Kodibo. Appear for respondent by NSA DCL. Yes. A step speed post only respondent by 8.
3, my lord. That's one. Obliged.
9. Item 9.
We'll issue notice first.
Lordship.
We're making it determinable fixed day.
Mine.
May hearing that. Or possible in a motion day.
Mine.
Third, Mr. R.S. Vishal, Learned Counsel for the petitioner. Mr. K. Jain, Learned Standing Counsel. Learned Counsel on behalf of Mr. S.C. Kayal, Learned Senior Counsel and Senior Standing Counsel GS. Special Standing Counsel. Special Standing Counsel.
Lordship.
GST for the respondent number
2 to 4.
Who is for 1?
Respondent.
Also had Miss P.
Borua.
Borua, and Central Government Council for the respondent number 1. So, issue notice returnable on July. August 2020. As so and so appears accepted. the formal notice, the copies into a case. On the basis of the instructions placed or stroke counter affidavit filed on behalf of the respondent and never will be made for to give final consideration to the writ petition on the writ article.
Can you bring 13 lordship permits 13? 11 some difficulty, my lord.
13.
Lordship, one submission that order dated 7/5/26 is an appealable order under 107. That may be recorded, Lordship.
Oh.
It is well within time, Lordship, because the order is passed on 7/5/26.
Mr. Jain has submitted that. Which order?
Lordship, page 23, another
The order dated 7/5/2026 within brackets NXIF is an appealable order under section 107 of the CDXT Act
Lordship.
2017. And therefore, the instant writ petition is not entertainable.
Lordship.
Item 10.
Wait, wait. The petitioner as plaintiff has filed a suit file. The year 2014 mile.
Hmm.
The defendant therein, they have filed a written statement. But after that, date of the main defendant, the suit was amended and the amended plaint was filed. Thereafter, during the
Which suit?
suit is my lord,
Suit?
page 21.
Page
21.
21.
Yes.
Suit is for what? Declaration.
It is for
and,
specific performance of contract.
Specific performance of contract.
Yes.
You are Jahangir Hussain.
Yes, plaintiff.
Okay.
The main defendant, my lord, after filing his written statement, died, my lord. Then suit was amended. Page amended plaint, page 29.
Arun Haq Khandokar
Yes.
expired.
My lord.
Then
Suit was amended. Page 29, my lord.
29.
Amended plaint. Thereafter, my lord, during
Rahul Haq.
his son,
Okay.
after, my lord, during the pendency of the suit, my lord, a compromise, the petition was filed, page 35. By the plaintiff, the substituted, my lord, the defendant and the other defendant, my lord. Accordingly, my lord, suit was decreed on compromise, page 38. By order dated 26/4/2019.
So according to this compromise,
Yes.
how much land?
My lord, 1 biga has been, my lord.
1 bighah.
Yes.
Okay.
Yes. Decree was passed on, my lord, page 30,
Yes.
38. Order dated.
38.
Yes. Order dated 26/4/2019.
Hmm.
Thereafter, my lord, petition has been filed for mutation of the name of the petitioner before the circle officer, my lord, Gauhati.
Mutation.
Yes. Lakshipur circle officer.
Circle officer.
Yes. Page 68, my lord.
After there is execution.
My lord.
What happened to the execution?
Execution, my lord, is pending so far payment of rupees.
So registered sale deed has been
My lord,
executed.
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 Yes.
Which order?
Page 55, my lord.
Okay, executed.
By order dated 5/12/2022, page 52.
Okay, executed. Yes, thereafter.
And the sale deed you also will find page 55.
Yes.
Then
Then
after that, my lord, the petitioner has filed an application for mutation before the, my lord, concerned circular.
by okay, page 67.
My lord.
Hmm.
Now, my lord, the circular.
Notice issued.
Yes. Now we are agreed by, my lord, the order dated last page, my lord. 91. 11/12/2025, my lord. Circular officer is denying mutation, my lord. One pretext or the other.
What is this higher court?
Well, he knows only.
But page
Since it is a
67,
compromise decree, my lord.
page 67,
My lord.
this is an appealable order.
Yes.
No, my lord. Once it is a compromise decree,
No.
only,
Page 67.
Yes, 67.
yes.
Read.
Page 67 is. a-
67, Annex 11. Please read in totality.
Your application for mutation after deed of registration has been submitted successfully on so and so. Your acknowledgement is so and so. Please use this acknowledgement number for taking the application and for any future communication related to this application. If the applicant has been accepted by the Revenue and Disaster Management Department, the service shall be provided within 60 days. You may raise an appeal. So and so if the service is not delivered within 60 days.
And secondly, if an order is passed,
My lord.
refusing
this
the
is so far my
public,
submission of application.
refusing the public service,
Right.
then that is also an appealable order.
I'm not agreed by that. I'm agreed by the last page.
Page 91.
Yes.
You are aggrieved.
My lord.
This is an appealable order. This is an appealable order.
To my understanding, it is not mine.
Then you go through the provisions of right to under, because statute says it is an appealable order. Is it not?
I'm not agreed by my lord non-supply of information. I'm agreed by the order dated whereby the,
I'm not saying about Assam right to, right to information.
my lord.
I am saying about Assam right to public services.
Mutation.
My lord. Mutation has been applied on the basis of a valid compromise decree. And the
Mr.
failed-
Soikia, I have understood
my lord.
everything. That you instituted a suit for specific performance of contract
Yes.
because you have executed a agreement for sale of land pertaining to 1 bigha, right? There is another bigha to the
It's not-
dependent, right? For some school or something, right? 2 bighas in total. So compromise decree has been executed on the basis of a compromise for 1 bigha in your favor, right? Decree has been passed. Then registered agreement has been executed, sale deed has been executed, right?
My lord.
Thereafter, you, on the basis of the registered sale deed and the decree, you have filed for you have filed an application for mutation, and mutation is notified to be a public service
Right.
under the Right to Public Services Act, and your application has been received, right? And the designated public servant is required to pass a region order. Mr. Whether it is a region order,
Some cases pending before a higher court lawsuit.
what higher court?
There is not.
You take instruction, what higher court? That Majomali.
Yes.
Who is Majomali?
He is also one of the defendant, my lord. And the party.
He is
to
for
the-
another 1 bigha.
Party to the compromise decree. He himself.
What instruction this circle officer has regarding
Higher court.
Majomali higher court? You don't know.
My lord.
Or knowing you are not disclosing.
No, my lord. Since he is a.
So I'll
party to
record
the
that you do not know. If you are a party, if we come to know later on that you are a party to the proceeding in the higher court, then it will be suppression of fact.
Doesn't. No.
We'll record your
My lord.
submission. Then you have to show.
He is a party to the compromise decree, my lord. How he can, my lord, sell?
No. It is, question is barring the remedy is different thing. But nobody can stop one from filing a petition like this.
But
When it is an appealable order,
Am I-
when it is an appealable order, you have filed a writ petition.
My lord, then this court of the civil court or my lord, jurisdiction has been under silence. Is a valid court, my lord, held.
That much to that extent, I am with you.
My lord.
You have not understood what I am saying. Problem is that, okay, heard Mr. P.J. Soikia, Learned Counsel for the petition. Miss Ann Bordolin, Learned Standing Counsel, Revenue Department for the response number 1.
About 2 and 3.
And Mr. N. Goswami, Learned Junior Government Advocate Assam for the response number 2 and 3. Post of para. On the basis, the subject matter of this petition is an application filed by the petitioner for mutation of a plot of land measuring 1 bigha, comma, covered by tag number 365 and patta number 194, comma, situate at village Khalisa Vita, page 42, Muslim Para, comma, Lakhipur Revenue Circle, District Gwalpara, Assam, subject plot. Bounded as on 4 sides, as mentioned in Schedule A to a decree in title suit number 12 of 2014, passed by the court of Learned Civil Judge Gwalpara Trial Court on 2/5/2019. Also, on the basis of a compromise petition filed jointly by all the parties to title suit number 12 of 2014, comma, the trial court on 26/4/2019 dispose of the suit on compromise, interiorly passing a decree declaring that interiorly holding that a decree of specific performance of contract be passed in favor of the petitioner within a plaintiff, within bracket, the petitioner, in respect of Schedule A করলো না Schedule B করলো BB of the compromise petition. Tough. Subsequently, comma, for execution of the decree, comma, title execution number, case number 02/2020 was instituted Close up. By an order dated 5/12/2022. The Nazir was directed to execute the registered sale deed on behalf of the judgment debtor number 1. That is the defendant number 1 in title suit number so and so, and the owner, erstwhile owner of the subject of erstwhile landowner of the subject lot, come in due course of time by taking necessary steps. The registered sale deed, the sale deed was finally registered by the sub-register Goalpara on 7/12/2022. Post of para. On the strength of the above compromise decree and the registered sale deed, the petitioner submitted an application for the notified public service quote mutation after deed registration unquote on 14/10/2025. Post. Para. The respondent number 3 as the designated public servant to extend the notified public service passed the following order on the application of the petitioner, page 91. Quote koi dibo. Para. Mr. Soikia, learned counsel appearing for the petitioner, has submitted that Mazom Ali was defendant number 2 in title suit number 12/2014. And he also was a signatory to the joint compromise petition, on the basis of which the compromise decree was passed on 26/4/2019. First off, the petitioner is not aware
May I
about
submit one? May I place one more? Page 68, mile. One notice has been issued by the circle officer only to the petitioner and the Rahul of Kundogan, not to Mazom Ali. How Mazom Ali came?
No, I don't know. Page 91 only.
Page
Petitioner
60.
is not aware of any proceeding. Petitioner is not aware about Mazom Ali approaching the higher court, any higher court, for resolving the dispute, and anything, any proceeding is sub judice at present, and therefore, but he has therefore contended that the grounds cited by the respondent number 3 in the impugn order dated 11/2/2025 is a non-existent one, and is not sustainable. Post of para. Mr. Goswami, learned junior government advocate, who represents the respondent number 3, shall obtain instruction as regards if whether any proceeding before any higher court, instituted by Mazom Ali, is pending before or is pending or not. First of, right?
Lots.
If it is not,
Lots.
and whether in such proceeding any restraint order
Yes.
has been passed or not.
Pertaining to the same land.
Let us see. Mr. Goswami has sought for a week's time to obtain the necessary instruction to release the case on service. You want any copy?
Lots.
Sir,
Soft copies.
Oikea, Land Council for the petition, shall furnish a soft copy of the writ petition along with annexer. Annexer is possible
Yes. Yes.
to Mr. Goswami by tomorrow, so as to enable Mr. Goswami to take the necessary steps from his end. Find out whether anything is pending.
3107, 31st July. Item 12.
Oh, right.
Yes.
May please. Manoj, we challenge in this, Manoj, a show cause notice dated 11/11/2025 issued in a GST matter, Manoj, on three broad grounds. One, on jurisdiction. Two, that it is a complete abuse. And three, on the ground of natural justice, Manoj. Lordship's pleases, I may just hand over a short executive summary, Manoj, I have prepared for your Lordship's convenience.
Where is that notice?
Yes, Malad. But before that, Malad.
Page.
Malad, the notice your Lordships will find at page 46. That is the impugnment.
What is the date of the notice?
Malad, 11/11/2025.
Yes.
Yes, Malad. Lordship sees, I have put in the parties, Malad, and then the prayers. Lordships will immediately come to the background. We are, Malad, a registered company under the GST, Malad, and engaged in the execution of works contract for large public water infrastructure projects in Meghalaya. Now, Malad, during the course of our business, we procure goods such as GI pipes, TMT bars, and cement. And the entire dispute, Malad, is for 3 financial years. For the financial year, Lordships will note down 2021 to 23-24, that is 2021, 22-23, and 23-24. Why I point this out specifically is there is an issue, Malaj, where your Lordships has also granted a stay. I'll come to that later on, Malaj. But Lordships will just pause here for a moment. Now, Malaj, when I procure the goods, Malaj, I have to ensure from the GST authorities, Malaj, that the person from whom I have, Malaj, brought the goods is GST registered, Malaj, and he has paid tax on those goods, Malaj. That is my domain as far as the GST jurisprudence is concerned. Now, what did I do, Malaj? There was a dispute inter se my seller that the seller actually did not receive any goods, etc. And therefore, his registration got cancelled. When this inquiry took place, Malaj, I found out that yes, there are certain irregularities. I have short paid GST by a couple of lakhs, Malaj, couple of crores. What I do, Malaj, I pay that on my own. Now, immediately, your Lordships will first come to section 74 straight away of the GST Act. I'm just coming to the legal point first, and then I'll take your Lordships to the fact. Section 74 of the GST Act.
Yes.
Lordship has 74. Straight away, Lordships will come to 74(5), subclause 5 minutes. Lordship has that? Yes. The person, Malaj, this is determination of tax not paid, short paid, or erroneously refunded. Malaj, this is the broad provision under which the show cause notice is supposed to be issued. 73 and 74. Now, 74(5). A person chargeable with tax may, before service of notice under subsection 1, pay the amount of tax along with interest payable under section 50 and a penalty equivalent to 15% of such tax on the basis of his own ascertainment of such tax or the tax ascertained by the proper officer and inform the proper officer in writing of such payment. So, Malaj, when the inquiry takes place, Malaj, under the GSTA provisions, Malaj, and before the show cause notice, I have an option, Malaj, to pay that very tax, Malaj. In such a case, what should happen and what is the action that they should take, Malaj, is mentioned in 6. Lordships will come to 6. The proper officer, on receipt of such information, shall not, it's a mandatory, Malaj, mandate, serve any notice under subsection 1 in respect of the tax so paid or any penalty payable under the provisions of this act or the rules made thereunder. So therefore, for the quantum that I have already paid, no show cause notice can be issued, and if any show cause notice issued, well, it will be completely non-est and without jurisdiction. That's a clear mandate as far as the law is concerned. 74.5 read with 74.6. Now, Manoj.
Let us see.
Yes, kindly come straight away to page 91. Admitted fact that I have paid. Kindly come to 91 straight away.
Yes.
This is the final portion, Manoj, of the show cause notice, and I take your lordships to para 11 first. In view of the foregoing, the petitioner, that is me, having principal place of business at so and so, is hereby required to show cause to the joint so and so, so and so, so and so within 30 days as to why the amount of rupees so and so, lordships will see 33 crores odd, Manoj. Lordship sees one. Avail during the period so and so to so and so in contravention of the conditions of eligible as stipulated in so and so shall not be demanded and recovered in terms of so and so as amended, read with so and so, as amended so and so, so and so. Now, my lords, may kindly see the second provision. What they are asking is the 20 lakhs odd, my lords. Now.
So this is regarding what? 33 crore.
My lords, 33 crore is regarding the amount I have already paid. Now, lordships will straight away.
Let us see that. Let us see that.
Correct. Lordships will see the very next sentence. Lordships will see the next sentence, sub-para 2. The amount of ineligible ITC, Lordship has that 20 crores, so and so, so and so, so received from the entities as enumerated in table B and C and voluntarily reversed during the course of the investigation, as well as interest of 1 crore 99 lakhs, my lords, and penalty of so and so, so paid, 15% shall not be appropriate to the government exchequer towards its GST interest and penalty liable. Ex facie. This is completely
No.
non-est and without jurisdiction.
What we understand by reading these two.
Yes, may I just say, what is the total demand? Total demand is of 33 crores. I'm not going into the rupee paisa ana broadly. Now 20 crores of that and the interest and the penalty is towards the amount I have already deposited, my lords, during the course of the investigation, which is clearly barred under 74.5 and 74.6. I will come to the rest aspect as far as the 13 crores is concerned. Lordships will just bifurcate these two for the moment, my lords, and look at it separately.
So out of 33, you paid 20.
20. So the 20 is as far as table B and C are concerned. Now B and C, I am accepting myself that yes, I made a mistake, my lords, and I am paying the duty voluntarily. And it's recorded so, my lords. So therefore, this quantum in the show cause notice, my lords, is completely bona fide.
The amount of, let me read.
Yes. May I say why?
Just a minute.
Yes, very well.
What is table B and C?
Yes, Mala, I'm so grateful for that, Mala. But before that, your lordships will just
What is table B and C?
Yes, yes, of course. But Mala, may kindly see just one document. I'll take your lordships immediately thereafter to table B and C, Mala. Page 88 of the show cause notice. Page 88. Lordships, that will quantify everything, Mala, for your lordships. That is why I'm bringing your lordships to page 88. Quantification of ineligible availment of ITC by the taxpayer. Lordship sees that topic right at the beginning. And then at the end of the column, my lords, IGST at the bottom of that column, first column, table 1, table J is 33 crores. Lordship sees that. Now next, voluntary payment. The taxpayer has reversed the ITC so availed from the entities as enumerated in table B and C, the details of the DRC3 raised to reverse the ineligible ITC so availed is in table K below. So, my lords, may kindly see the amount at the bottom of that chart, my lords, that is that table K of 20 crores 31 lakhs. And thereafter, my lords, it's the interest of 1 crore 99 lakhs and 3 crore 04. My lords. So this is what it is as far as table B and C. Now your lordships wanted to see what is table B and C. I will take your lordships to table B and C. That is at page 48. Lordship has 48 page number.
Yes.
Yes, my lord. So table B has a component of 1 crore 77 lakhs, my lords. And lordships immediately at 49, lordships will see table B.
Operated whenever it was revealed that to create entities not right now. This is table B.
Yes, my lord. Table B, my lords, total 20 crores. The lordships will recall. So 1 crore 77 is table B and 18 crores 53 is table C. Immediately on the page after that, my lords. So sum total is what I showed you at page, my lords, 91. That's the summary. And also, my lords, I showed your lordships.
How this 33 has been arrived at?
Yes, my lord. There is a separate component in table K of 13 crores. Lordships will come to table K. It will make it clear.
Page?
Page K would be table. What is the
Page
13
88,
crore?
Lordship. 88.
Table F. I'm so sorry, my lord. I'm grateful, my lord. Table F. Page 58, my lord.
Page?
58.
58.
Yes, my lord. Table F. My lord, I'll come to this aspect later, my lord.
Table F.
Yes. But I'll pause for a moment, my lord.
Yes.
Well, I'll pause for a moment, my lord, if your lordship pleases.
Yes.
I'll pause for some time. Lordship, I believe lordship
yes.
would take a break. So, my lord, I was on table F, my lord.
Table F.
The table F, my lord, is of the separate part B. My lord, I am first dealing with part A, which is about the 20 odd crores. Part B, relating to table F and 3 suppliers, I'll come to that later, my lord. So, therefore, as far as part 1 is concerned, my lords, there are 3 things that have happened. 1, I'm just summing it up, my lords. Section 74(5) says that you can deposit. 74(6) says in case you have deposited, go that, no show cause notice. My lords, the department in the show cause notice itself admits that I have deposited. Now, my lords, why did I say besides jurisdiction, there is a complete, my lords, let me not put it as an abuse, complete non-application of mine. Let's put it slightly, let me pitch it slightly lower.
Page 91, they have admitted that you have voluntarily reversed.
Yes, absolutely. I'm so grateful, my lord. So therefore, it is non-applicable technically. Otherwise, therefore, the show cause notice should not demand 33 crores more. Had they applied their mind, they would have only demanded, my lord, 13 odd crores with penalty, interest, etc. I'm just parking part B aside, my lord. Even that is without jurisdiction. I'll demonstrate that.
No, this is firstly a show cause notice.
I agree. I completely bow down. But the question is,
if we read clause 1 and clause 2 together of paragraph 11
correct
of the show cause notice,
right,
They have admitted 33 crore was the total demand,
That's right.
according to them.
Yes,
Out of them, 20 crore you have deposited or voluntarily reversed
correct,
during the course of investigation.
correct.
So
That is the
meaning
difficulty.
thereby, it is a 13 crore demand.
No, it is a 33 crore. That is the difficulty. And that is why I am before your lordships. And that is why my contention that it is without jurisdiction. Kua part 1. Malad, what is the prejudice that causes to me and why does the revenue normally do this? Let me explain that concept, Malad. Normally what happens, Malad, normally the order in original, which will be passed by the additional commissioner, etc., is an order of confirmation. Immediately thereafter, Malad, I have to file an appeal. There is a pre-deposit. So, Malad, if it is 13 crores, then the pre-deposit just becomes 10%. If it is 33 crores, my quantum increases, Malad. So that is the difficulty. Now, Malad, so that is why.
Why do we prejudge?
Malad, I'm not prejudging. This is a clear, Malad, mandate of the law that in 76, you cannot issue a show cause notice, Malad. Malad, kindly see 76, 74.6 again. Shall not is the word used, Malad. Kindly see 74, Malad. Again, 74.5.
Oh, this is clause 2.
Yes.
Shall not be appropriated to the government exchequer towards its GST, interest and penalty liability.
Correct.
So what is the meaning of appropriation?
Malad, appropriation, Malad, mean as to why this amount should not be appropriated to the government exchequer. Malad, this is the GST amount paid.
So
I have paid the GST.
What is the meaning conveyed by clause 1 and clause 2?
May I say this? 33 crores, Malad, clause 1 is the demand clause. Malad, 16 says, why should this amount deposited should not be appropriated? By filing my return and depositing it, what have I deposited, Malad? I have deposited the GST only, nothing else. So why should the demand of 33 crores to be there? Malad, kindly see 74.6, one more moment. Malad, in the light of these facts, let us reread 74.6. This is clause. Lordship says, the proper officer, that is the person issuing the show cause notice, on receipt of such information, he had such information, Malad, shall not serve any notice. So where is the question of issuing notice on that 20 crores, Malad, that I have deposited? Under subsection so and so, in respect of the tax so paid or penalty payable under the provisions of this act or the rules made thereunder. So, Malad, the notice itself cannot be issued on this. The whole mandate is that, legislative mandate is that. That is point number 1. Now let us come to, Malad, the balance 13 crore as far as, Malad, the 3 other suppliers are concerned. Malad, may kindly come to table F again. Page 58. Now, Malad, may kindly see the names of the 3 people, and Lordships will just note down a couple of dates, and I say this for a reason. Malad, KSP Electro Engineering India Private Limited, and the amount is of 4 crores odd, Malad. Lordship sees that. Galaxy, Malad, again 4.22, and Nightingale Vanajya Private Limited, again about 4 crores odd, Malad, totaling 13.13. Let's come to KSP Electro, Malad. Lordships will just make a note on the side. My transactions based on which I am claiming GST. Lordships will just note down. March 2022, and Lordships will take it from me that I can show that from the show cause notice also. I'm not, Malad.
2025?
March 2022 to August 2023. And, Malad.
Which year?
Malad, 2023. So my transactions or the GST benefit that I have taken is for the period from March 22 to August 2023. Lordship has noted that. That is KSP Electro.
Yes.
And Lordships will immediately below that write down that KSP Electro's GST registration was cancelled on 6/3/2024 after I have availed the benefit. I'll explain your Lordships how this is relevant in a while. Then your Lordships will come to 2, Nightingale Vanijya Private Limited.
2 is Galaxy.
Well, it's Galaxy very well. Lordships will take Galaxy Mechanical. Transaction date is, my lords, December 2022 to August 2023.
Yes.
And the date of cancellation is 21/12/2023.
Yes.
And, my lords, Nightingale's is the same as KSP Electro, my lords. That is, transaction is March 2022 to August 2023, and the cancellation is 6/3/2024. Now, my lords, what are the facts that are not in dispute? Facts that are not in dispute is that on the date when I did the transactions, they were a registered GST person who supplied me the goods, my lords. 1. 2, they paid GST on those goods, of which benefit I have availed once I received the goods, my lords. I have received the goods in my factory, not disputed, my lords. I have, my lords, as a bona fide purchaser, what do? I go to the GST portal, my lords, and I can show, and I go and see the registration, my lords. Give me those documents, my lords, and I see how much of duties they have paid, my lords. Just give it to the court. And after I have seen that they have received these goods after having paid duty, my lords, I buy the goods. And based on that, I, through banking channels, not through other channels, I pay the GST and I pay those to that particular person. Now, my lords, their entire premise of that 13 crores is based on the fact, oh, I have now terminated the GST registration, so therefore you are not entitled to receive any GST benefit. My lords, the vested right has been created in my favor, my lords. I have, based on certain understanding, taken the benefit of GST. How can you retrospectively, my lord, say, okay, I have cancelled that and therefore you are not entitled to the benefit of it, my lord? I ask myself that question. And these are facts not in dispute at all. And what have you shown, my lord, to avail GST? I have shown a sample invoice, my lord. I have shown my e-way bill, copy of the ledger of the supplier, my lord. Now, all of that has been done. Now, my lord, the question is all that they are jurisdictionally, well, it's complete non-application of mine.
No, question is issuance of so-called notice can be a matter. So-called notice can be interfered with on limited grounds. Complete lack of jurisdiction.
Correct.
Right.
Yes.
On the part of the authority to issue the so-called notice.
I'm so grateful.
Now, under section 74 or section 73, it has the jurisdiction to issue that which authority has issued the notice.
DGT.
It is not.
First ground.
Yes.
Complete lack of jurisdiction on the part of the authority issuing a notice.
Very well.
That I don't think that is your.
And that is not even my case.
So otherwise, a so-called notice is a step in the process of determination of an issue raised therein. So it can be very well replied to and responded.
Lordship.
Right. There is no question of any pre-deposit at this stage.
Lordship.
Right. Then secondly, this 20 crore, this 33 crore minus 20 crore, clause 2, they have said already voluntarily you have discharged that liability. So there is a provision in subsection 7. If we read together clause 1 and 2, then the provision of subsection 7 of section 74 would come into picture. Right. And by reading together clause 1 and 2 of this notice, it appears that it is a case of subsection 7 of section
correct.
74.
May I? If your lordship.
Yes, please respond.
My lord, there are three aspects here, my lords. Lordship is, I mean, well known, my lord. Whirlpool is a clear judgment. Vico, my lords, is a clear judgment. There are three
No,
aspects to it.
against the show cause notice, there is no such
Bar. It's a matter of
no such
policy
bar.
and
But
a
additionally, there is no such appellate provision.
That's right,
Right.
my lord. But
To
there's a-
interfere in re-jurisdiction.
correct. That is your lordship's discretion. I cannot say anything on that. It is a purely matter of discretion. The only question that I ask myself is whether I'll be able to touch your lordships. That in this case, at least, my lords, there is complete abuse. If I'm able to show that, my lords.
Because they have said in clause 2
Yes.
that you have voluntarily recharged.
Then let them,
reversed.
therefore,
If we read
let them
together,
let them say, therefore, in terms of that 20 crores, that duty is not going to be imposed. Today,
because total demand was 33 crores.
33.
Right.
Right.
Out of that 20, you have voluntarily reversed.
They are saying 20 paid and 20
And
is correct for that.
you have been asked to show cause
Correct.
why it shall not be appropriated to the government exchequer.
That's right.
So tentative view is that it is a case of subsection 7 of section 74.
Lordships. Correct.
Well, let's
Tentative view
That-
subject to
correction, whatever I have to
Correction.
say. Well, let's
then
that
it
amount.
can be very well responded to regarding 13 crores.
No, Malad. With greatest of respect, my answer is no. Malad, why so? Malad? Lordships will just see.
Because this is for interfering at the show cause notice stage.
Yes, my lord. And lordship has interfered in several other cases also. Not on this aspect.
This aspect is different
Well, this aspect is directly at the court.
regarding the 13 crore.
13 on the 13 crore, I'll come to that later. Malad. On the 20 crores, I am more aggrieved. I am aggrieved against both. But I am more aggrieved against the 20 crores also, my lords. That is because 7 does not protect me. 7, your lordship says 7 completely protects me.
No. 7 is the jurisdiction
Yes.
for the proper officer to issue a notice. Let us read 7.
Yes, my lord. Lordships will just read the show cause notice for a while.
Because of the language used in
Yes.
clause 2
Yes.
of that part, paragraph 11.
Yes, my lord.
Right.
Yes.
They have admitted that
Correct.
you have reversed.
Yes.
And why it should not be appropriated to the government.
Lordships will
And
just
if we
see.
read together,
That's it. Lordships will read together, but before that, Lordships will also see the language of the show cause notice at page 91 before I read that. Page 18, 19. The amount, Lordships pleases. My lord, show cause why the amount of ineligible ITC of 33 crores availed during the period so and so in contravention of the conditions of eligibility as stipulated in section so and so shall not be demanded and recovered. Lordships will mark those words, my lords. Demanded and recovered in terms of subsection 74, my lords, as amended so and so, along with interest payable along with section 50 so and so. Right. So what is the
Right, Mr.
recovery
Sharma,
therefore?
it happened. Clause 1 happened
Yes.
prior to clause 2.
Yes.
Clause 1 happened
Yes.
prior to clause 2.
That's right. Let us.
Right?
Yes.
Clause 2, you made the reversal.
Correct.
Right?
Yes.
After happening of clause 1.
No, I have deposit. Malad, I have my.
Let us see the dates then.
Yes. When did I deposit, Malad? Lordships will see.
Let us see.
Yes. Kindly come back to the chat. I'm so grateful for that question, Malad. Page 88. Page 88, Malad, table K. Correct. Malad, Lordships will again note when the show cause notice is done, Malad. Show cause notice is 11/11/2025. And on what dates have I deposited, my lords? Lordship sees table K. Lordship sees the dates on table K. Everything before.
No. So cause I'm not saying that so cause notice is not in 11/11/2025.
Correct.
I am saying that this occurrence of this demand for 33 crore
Yes.
arose prior to voluntary reverse.
Well, maybe. But the
Right.
question is, could he have in terms of 74(6) issued that notice at all of that? I'm not disputing that.
It is whether it is a case of 76 subsection 6 or subsection 7.
Yes. So that is their demand. I have paid each rupee paisa ana.
So
There is no question of a shortfall.
33 crores, that is a demand for which the demand arose.
Right.
Right. Then you voluntarily reverse 20 crores.
I have
Right.
reversed.
Why they say that? Why it should not be appropriated to the government exchequer?
Malad, I have
Meaning thereby could be that it is apparently under subsection 7.
Malad, Section 7 is of a different.
Because
may I?
your right to respond
Correct.
is still available.
May I?
And show cause notice, we are discussing not a final order.
Yes, of course, Malad. That is exactly the
It
thing.
is a step towards.
So therefore, let me say,
Because law says
what I want today.
once the SSC or the noticee satisfied, is able to satisfy, final order could altogether be different. Law is also that
That's right.
regarding a show cause notice.
Of course.
What you are agitating before me, it could very well be agitated before the adjudicating officer.
Malad, with the greatest of respect, if he did not have the power to issue a notice qua that amount, will it not be without jurisdiction? Is my question before your lordships, Malad. Let us therefore.
Jurisdiction to issue the notice is
Malad,
available.
that's a separate concept, Malad.
Right.
That is
And
one is the power.
jurisdiction to issue a notice wrongly
Yes.
is separate issue.
Malad, what is the language of 74(6)? Let us read Malad 74(7) first, and let me satisfy your lordship, Malad, as to why 7 is not applicable, and then I'll come to 6 again. Lordship will see 7. Where lordship has 7 now, Malad. Where the proper officer is of the opinion that the amount paid under subclause 5, Malad, falls short of the amount actually payable, he shall proceed to issue the notice as provided in subclause 1 in respect of such amount which falls short of the amount actually payable. Malad, I have not short paid anything. In respect of table B and C, I have paid rupee paisa ana. So where is the question, Malad, of him issuing a notice under 6 for me as far as this amount is concerned, Malad? 13 crores, I'll part that, Malad. I'll come to that.
What are
later.
your other contentions?
Malad, that is my first contention, Malad, as far as this is concerned. My second contention, as I said, in terms of the 13 crores, is that, Malad, there can be no retrospective cancellation of the licenses. And if I have availed benefit of that, Malad, that benefit cannot be taken away.
Retrospective cancellation is of the other entities.
Yes. Malad,
No,
however,
even if it is retrospective, I'm not examining that retrospective part. still.
correct. No, admittedly
But
so.
three entities are KSP Electro Engineering,
Correct.
Galaxy Mechanical,
Correct.
and Nightingale.
That's right. Malad, registration cancelled is in 23 and 24. The transactions or the benefit of GST has happened much earlier.
But that otherwise, in the GST Act,
Yes. Cancellation can be retrospective.
yes.
I have no doubt about that. And I'm saying so upfront, they could have done for them. But can you reject the benefit I have taken? My GST registration is not under cancellation. Malad.
Not under cancellation.
Yes. So for somebody,
But-
as a customer or as a purchaser, I have to do a due diligence, Malad, that I have, Malad, the tick boxes are that that person is GST registered and he has deposited the tax as far as the goods that I have purchased. I have given the screenshot from the GST portal to your lordship, Malad, that clearly demonstrate that goods that have come to me are duty paid, my lords. If those goods are duty paid, what else could I have done, my lords, to ensure? It is beyond me. It is completely beyond me, my lords, to go and
Right,
investigate.
it is beyond you.
Yes.
No doubt about
So
it.
therefore, why should I be saddled? My lord,
No, you are not saddled.
I am saddled with the 13 crores.
No,
Why?
you are even asked to show cause.
No, show cause, but as
Not
a result
saddled
of,
as on date.
My lord,
Demand not
kindly see.
confirmed, Lordship.
My lord, what will happen? If, well, and this is something that I am only seeking as an interim. Well, I am only seeking
That
today.
is why I am examining your
Well,
case.
I am saying that,
Otherwise, I would have straightway issued a notice.
correct. Well, I do not want any coercive steps to be taken against me. That is all, my lord. Now, the other aspect, my lord, that is there in this is twofold.
Because retrospective cancellation of registration of those entities
Yes.
are cannot be challenged by you, but question the consequence
Yes.
arising out of
Should I be
that will be that can be agitated.
agitated, my lords? And if it, my lord, if that is the sole ground,
But we are
If
into
that
a
is-
very limited spare.
jurisdiction,
so-called
lordship jurisdiction or discretion today is very limited, my lord.
so-called
Whether I have
notice.
touched your conscience, my lords, to interfere or not is
That
the
is
question, my
what,
lord.
because the
Absolutely, my lord.
jurisprudence regarding interference with the so-called jurisdiction is very limited.
Absolutely, I bow down, my lord. I
Complete
bow down.
lack of jurisdiction
I
is
bow down.
one.
I bow
But issuance of notice
Yes.
based on some wrong interpretation of statutory provision, that can very well be corrected if the noticee can satisfy the authority who has issued the notice.
By filing
Because
reply, Lordship.
if you argue that this man has no authority to issue a jurisdiction, it is a complete different matter.
My respectful submission, my lords, in terms of 74.
Additional director.
Additional
Yes,
director.
if he has
Well,
no authority to issue, then
He-
absolutely I'll give you complete stay.
My lords, may kindly see 6 for a moment again, then I'll keep this point on rest, my lords. 6 for a moment again. My lords, the proper officer on receipt of such information.
Because the section 74 starts with
Yes.
where it appears.
Correct. My lords, kindly see, my lords have to read 6 independently also. Kindly see the language of 6. The proper officer on receipt of such information. Now, can it be disputed that on the date of the show cause notice?
Why the petitioner,
Yes.
in response to the so-called notice,
Yes.
should not file a reply to
Well,
that?
I filed the reply.
They are filed, Lordship.
I
They are
filed the reply. That is what I'm saying.
Where is that?
We only filed a letter for.
We have letter, my lords, enumerating all of this, my lords. All that are on record, no dispute. Lordship will again see sick.
Where is your reply?
Lordship,
Reply is there.
Page 101, Lordship, Annexure C.
My lords. Yes, my lord. That is a letter for eligible copies, my lord. I'm sorry. My lord, that is not a
There is no
full-fledged.
reply.
My lord, my apology. There is no reply. Lordship will see 6 for a moment. 74-6.
I have read it meantime.
Just one more time with me, my lord. The proper officer on receipt of such information shall not serve any notice under subsection 1. My lord, if today notice is issued, will these words have some meaning, my lord? Will these words not become completely odious, my lords? In case your lordship says that I'll have to file a reply and still go and adjudicate, and he'll have the right to adjudicate this issue, my lord.
Firstly, one subsection can be read independently. An entire
Therefore, I
subsection
say-
can be read
Therefore, I say
together.
there are very important questions of law that arise in this, my lords. So therefore, I would beg your lordships to interfere. There are 2 other points, my lord. May I just quickly enumerate these 2 points, my lords? My lords, first point, other than the
Subsection 9, the proper officer shall, after considering the representation made by the person chargeable to tax, determine the amount of tax,
that's right.
interest, penalty due to
But
such.
there is a clear
and-
bar under 74-6 to issue notice on that 20 crores odd, my lords.
But reading together, I am not getting that satisfaction
That is the
parameter.
difficulty, my lord. In
Clause
all-
1 and 2.
my lord, in all this
Together.
cases, my lord, why do they do that? May I say this again, my lord? They do that only to prejudice me and squeeze out more money as a deposit. That is the primary reason. And that is why I've come begging here before your lordships. Otherwise, there was no reason.
The event which might occur in future.
Right. But it has occurred for me. Notice has been
That
issued.
does not
Whereas
appear.
there's
That
no
does not
power to
appear,
issue a
Prime Minister.
notice, Balaj.
That will occur at a foreseeable future after the order passed in, or the order in original to be passed by the
Authority.
adjudicating authority. But that stage has not come, which is to be hesitated.
But could he have issued a notice, Balaj?
That is what
paid-
I'm trying to find out. Reading,
if-
put the clause together.
Then how would your lordships, just for my
Because this
satisfaction,
will be appropriate. This 20 crore, they will appropriate. Meaning thereby, out of 33 crore, 20 crore will be appropriated.
Well,
Total demand is 33 crore.
Well, there are different, lordships will understand. Total demand is 33 crores. But what is 33 crores? 33 crores, my lords, is divided into 3 tables. Right? What are those 3 tables? Table B, C, and F. B and C, my lords, is a separate demand altogether of some different vendors, not of these 3. Not of this Nightingale, etc., etc. my lords. These are completely different suppliers. So that demand, those people has been completely satisfied. So why should I be saddled in otherwise, what meaning would your lordships give to the words, my lords, shall not serve any notice? Should it be become completely redundant, my lords? There is no other meaning that can be given to this, my lords, other than that you cannot issue a notice. This is for the benefit of the SSC, my lords, and therefore it has to be read or interpreted to my benefit. The benefit of this cannot be given to the revenue, my lords. The intent is to give me a benefit. Shall not serve. There is a clear jurisdictional bar. That is my respectful submission. My lords, I'll satisfy your lordships when I argue finally, my lords, on these words, my lords, how on edistem generis and on how this clause has to be read separately. I have not got those judgments, my lords, but this is a complete independent provision which gives an SSC a benefit of law. This is for my favor, my lords. I should not be saddled. Basically, my lords, what are they doing, my lords? They are trying to demand duty twice over from me, my lords. I have deposited that, yet they will issue a final order against me for 33 crores, my lords. Where do I go? What do I do, my lords? Now, kindly see the other 2 points, my lord. Very important points, my lord. And your lordship has interfered in one such issue, my lords. But I should write straight away, completely confess, my lords, there is this principle, which is, my lords, on GST regime or GST jurisprudence, this is a hot issue or a hot potato, as they say, my lords. Now, what in the whole of India, what the GST authorities have been doing, my lords, they have been issuing show cause notice in a conjoint manner for different assessment units. The question was before the court, my lord, as to whether a single show cause notice can be issued for different assessment units. Now, Bombay High Court, the matter is pending before a full bench, my lords, where the judgment was in favor of the SSC. Kerala High Court is again in the favor of the SSC. Karnataka High Court again in the favor of the SSC. Jharkhand, favor of the SSC. But there are certain other high courts, including this court, recently, Justice Debashish Barwa's judgment, my lords, where the court has come to a conclusion that a revenue can also, my lords, do a joint assessment. That matter is pending before the DB now. Appeal, I am told, has been filed. But the law again on this aspect, in this case, that is exactly what has happened. The 33 crore demand, as I showed to your lordships, is for 3 different assessment groups. In that situation, your lordships, in a matter, was pleased to interfere, my lords, and grant no coercive steps, my lords. And that is all that I am begging today, till those issues are decided. And my lords, may I also say that that issue now has been taken up to the Supreme Court by both the SSC and the revenue from different jurisdictions, and that matter is pending there in the Supreme Court. And the law is settled when there are serious issues, my lord, which are pending, where there are difference of opinions, my lord. The High Court should not interfere, my lord. High Court should stay their hands, my lord. And in the meantime, till that issue is decided.
Those points are there are various decisions
Yes, my lord, exactly.
which
That-
are
My lord, I am saying,
not in
my lord,
consonance with
have
one
only-
another. There are other decisions
I have,
that, be that as it may,
correct,
it is pending before the High Court or before the Supreme Court.
Correct.
Unless we have given a restraint order
correct.
not to decide, why you will not decide? You go and
That's
proceed
right.
and decide.
I am begging, my
But
lord,
so far as law is concerned,
correct. So I am
one
begging,
is that
not on one
if-
individual.
what the coordinate bench or any larger bench of this court has decided.
No, my lord, larger bench of this.
And
court has-
other high courts, those will have persuasive value.
Correct.
But so
So
far as
therefore I was-
coordinate bench or larger bench
Therefore, I
of
was
this court.
upfront, my lord, and I said so that there
Right,
is a
right. You have rightly said.
My lords, but I am not praying, my lords, on one point. I am asking your lordships, my lords, to look at it cumulatively. In terms of all the
Sorry.
3-4 points that I have mentioned, my lords.
Okay, what is your third point?
My lords, the third point is this, my lords, that the issue of clubbing is a point that is now pending before the Supreme Court, my lords. The point of clubbing is a point.
Whether
in-
that against that coordinate bench judgment,
Yes,
an appeal has been preferred.
Yes.
Whether there is an order of stay.
No,
there is
Lordship.
no stay, my lord. The appeal has not even been listed. is what
Lordship, appeal has been listed. Their only prayer is that in the writ petition, they have asked for 6 prayers.
No,
And-
that is
and
a
one-
separate
one-
matter, my lord. My
Lordship-
learned friend,
No,
I'm
regarding
aware of
clubbing,
that.
Lordship,
clubbing.
May I say?
They have admitted
a-
that they have admitted that the authority can issue the multiple show-cause notice, that they have admitted. Only writ appeal has been filed, Lordship. They are seeking that the matter should be remanded back to the single judge so that he can decide the other 5 issues. That has been asked in the writ petition, not on the multiple show-cause notice, Lordship. Lordship,
May I assist, my lords?
that matter is also now going on in court number 1, Lordships.
May I just assist on that? My lords, what Justice Debashis Barua decided was about 3 or 4 appeals. One of that was taken up and also heard. In that, Justice Barua decided only the issue of clubbing. There are other issues like what we have raised here, my lord. There were other issues also.
You can say the bench.
Yes, my lord. So Justice Michael, I think in that division bench, my lord, that bench said, since and there was a submission made by the SSC that on the clubbing issue, my lord, let's not get into that. On the other issues, the judge has not decided. So what was done? It was remanded back. But the stay that was granted earlier is continuing in terms of that order. My learned friend probably has
Lordship,
order.
that no
Just once
course
again,
action, Lordship.
I am not finished. My lord, against the other orders, other appeals that are other writ petitions of quantum, right?
Yes,
What is the
correct.
on quantum? That appeal has been filed, and that appeal is yet to be listed. My lords. That is the main appeal. That is the one along with Tata Power. That is where the core issue will also get decided. My lords. That is yet to be decided. Is my submission. My lord. Now there is a third aspect here, my lords. Rather a fourth aspect in as far as this petition is concerned. The fourth aspect is, my lord, by letter of 13th of March, my lords, I asked them for legible copies. Kindly see what has been given to us. Now, what has been given to us, my lords, is, my lords, whether it is the statements or whatever, is completely dim and unrecognizable copies. My lords, may I kindly show what has been given to me? And my lord, if I could have filed all of that, but if I would have filed, my lord, that would have never come before your lordships, my lord. Because it's so dim. Can I just hand over that? There are 71 documents relied upon, as far as I am concerned, except for certain, my lords, documents which are just about 10 pages, which has been downloaded from there. Everything else, that is 2,500 pages, my lord, is all this. Lordships will keep scrolling
Some
down.
call has come.
Huh?
Some call has come.
Oh. और इसको दिखा दी. Well, so Lordships will take it from me that all the documents is exactly like this, dim, it's not readable at all.
Yes, Mr. Jain.
My Lordships, I'll just summing it up. My lords, so my respectful submission is, my lords, not on one point, cumulatively on these 4 points, my lords, I say.
Third point?
Well,
This
let's-
is 4 point,
well,
legible copy.
Third point, that is the fourth point, my lord. My
First thing is 74-6.
74-6. No so-cause notice could have been issued. My lord. The second point is, that is QA my lords, the 20 crores. For the 20 crores. There are two sections to this, as I said, 13 crores and 20 crores. As far as 20 crores is concerned, no show cause notice. There is in the clear bar in with the words in 74(6), my lord, no show cause notice could have been issued. The subclause 2 of the show cause notice, my lord, whichever your lordship sees in page 91, cannot be read that, okay, I will appropriate it later. There is no provision for appropriating it later under 7. That is only if, my lords, that would have been a separate show cause notice. In this case, as far as B and C table are concerned, each rupee paisa ana has been paid, my lords. Now, coming and as far as the first clause is concerned, that is the 20 crores, I am also on the point of clubbing. The point of clubbing, my lords, is a issue where the SSCs and the revenue is at loggerheads, my lords. That is an issue of a question of law of serious implication, my lord. That is being tested in before the Supreme Court now. Today, if I am saddled with to file a reply, I will have to, my lord, submit that there is no clubbing. There can be a clubbing. So today, when that issue is being decided by the apex court itself, my lord, and I will, my lords, kindly show an apex court judgment, my lord, on this, on the question of the timing, where the Supreme Court has said that in such cases the High Court should not, my lords, High Court should not go into it and decide matters when the issues are before us, my lord. But be that as it may, your lordship is right. Your lordship is right.
You give the handle.
Correct.
We'll decide.
Lordship is right. My lords, kindly see then on the other aspect, as far as the 13 crore part is concerned, my lords, my submissions are twofold. My submission 1 is, my lords, how am I to be faulted? Today, the entire fundamental core of the show cause notice is I am denying you 13 crores because you have the registrations of these 3 parties, my lord, have been cancelled. If that is so, my lord, then no liability of with that 13 crores. Lastly, my lords, as I said, the documents itself has not been given, my lord. I understand that can be given, my lord. So therefore, kindly till that decision is taken by the revenue, my lord, of giving me the documents, giving me time to file, my lord, etc. Lordships will protect me from coercive steps, and I hope and believe, my lord. But by then, the core issue of the, my lords, of clubbing also will be decided, and, my lords, I will be able to, my lords, argue that issue out. That is all.
Yes, Mr. Joint. Legible copies.
Lordship,
If it is not.
Lordship, they may file an application that their department.
No, already filed in.
Lordship may then Lordship in this case Lordship may give a direction to the department that to file to submit them the legible copies so that they can file their reply.
Okay, I'll be granting you.
Lordships.
15 days time. You
Lordship.
give them. Till
Lordships.
then, you should not proceed further.
Lordships.
Keep this.
Very.
Thereafter, you will agitate.
Very well. Very well.
Because we are into so-called jurisprudence.
That's right. I completely bow down, my lord. Your lordship's window is very narrow, and I have to, my lords, enter into that discretionary issue as far as your lordship is concerned, my lord. I see that, my lord. But, my lord, 74(6), I will try and agitate that point on the next occasion slightly more, my lords.
Yes, better. Heard Mr. P. Sharma, Senior Counsel, listed by Miss
Shreya Devi.
S.
SHREYA, Shreya Devi.
Learned Counsel for the petitioner. Mr. K. Jain, Learned Counsel. On behalf of Mr. S.C. Kyle, Learned Senior Counsel and Special Counsel, CGST.
Lordship for DGGI.
For?
DGGI.
Or DG?
GI.
What is that full form?
Lordship Directorate of Goods and Service Tax.
Okay. For all the respondents.
Lordships. For all the respondents.
First of para. The petition as assailed in this writ petition under Article 226 of the Constitution, the petitioner has assailed a demand cum show cause notice issued in form GST DRC 01 dated 11/11/2025 under section 74 within bracket 1 of the Central Goods and Services Tax Act 2017 and section 122 of the GST Act 2017, RW Section 142 of the GST Rules 2017, post para. The relevant excerpts, the following excerpts. It will be following excerpts from the demand come focus notice are of relevance. Page 91. Para. The Land Senior Counsel preparing for the petition has submitted that out of the total demand of rupees 33, the total demand of rupees 33 crore, 44 lakh, 23,578 comprised of two components. One comprised of two components, rupees, within bracket, small one, rupees 20 crore, 31 lakh, 23,147, and two, 13,000, 13 lakh, sorry, 13 crore, 13 lakh, 442. Full stop. Insofar as rupees demand towards rupees 20 crore, 31 lakh, 23,147. As regards purported ineligible ITC is concerned, comma, the petitioner had already reversed the amount voluntarily during the course of investigation. Full stop. It is further submitted that the other part of the demand amounting to rupees 13 crore, 13 lakh, 442 pertain to three entities are relatable to three entities. One, page 58, KSP Electro Engineering India Private Limited. Roman to Galaxy Mechanical Engineering Equipments Private Limited. And three, Nightingale Banijya Private Limited. Post stop. The transactions done by the petitioner with the said three entities at the time of the transactions, at the time the petitioner had made transactions with the said three entities, comma, the said three entities had valid registration under the GST Act, right?
Yes, sir.
Full stop. It is contended that just on the basis of cancellation of their registration under the GST Act with retrospective effect, the petitioner could not have been saddled with a demand towards rupees 13 crore so and so. Full stop. It is further submitted that after receipt of the demand cum show cause notice, the petitioner submitted an application requesting on 10/3/2026, requesting legible copies of all 71 number of documents referred to in the demand cum show cause notice by the adjudicating authority, so as to enable the petitioner as a noticee to represent their case in an effective manner. Full stop. It is submitted that in response to the said application, though the petitioner had received the documents were not legible enough to effectively respond to the impute notice. Full stop. Para. Mr. Sharma, learned senior counsel appearing for the petitioner, has further contended that in the demand cum show cause notice, the demand has been met for
Three financial years.
3 financial years in a consolidated manner. And it is his contention that the maintainability of such demand in a consolidated manner for more than 1 financial year is an issue which is pending before the Honorable Supreme Court.
May I also give the SLP number, my lords?
In
SLP.
SLP number
I will just give it to the court master.
so and so. First of all, para. In response, Mr. Jain has submitted that if the copies of the documents requested by the petition are not legible, such legible copies of the same documents can be provided to the petition. First of, to that extent, he has contended that the petitioner has said a demand cum show cause notice without submitting any reply to the show cause notice. First of, he has further contended that he has further referred to the provisions of section following subsections of section 74 of the GST Act, subpara 1, subsection 1, subsection 5, subsection 6, subsection 7. Para. Referring to the above provisions of section subsections of section 74, he has contended that there is no lack of jurisdiction on the part of the proper officer to issue the demand cum show cause notice. And if certain facts are incorrectly interpreted, interpreted in the show cause notice, the noticee can very well respond to the show cause notice. He has further contended that a show cause notice is merely a step towards final determination of the issue raised therein, and on receipt of a reply from the notice, comma, a final decision of the adjudicating authority can altogether verify. First of the matter of record consideration, issue notice returnable on. First of as all the respondents are represented by Mr. Joint, the notice is made returnable after 20 days. Extra copies within 2 working days from today, as the contention proposed of the learned, the respondents shall furnish legible copies of the documents requested by the petitioner, while the application that is so and so be provided to the
Noted.
petitioner within a period of 15 days
15
from today. Post of para. Having regard to the contentions advanced by the learned counsel for the petitioners, petitioner, with regard to subsection 6 of section 74, and the contra submission advanced by the learned counsel for the respondents, having regard to subsection 7 of section 74, it is provided in that there shall not be any coercive action against the petition.
I'm so grateful.
So the remand comes to notice till the returnable.
Lordship may make it clear that your Lordship is just granting no coercive action because no legible copies have been provided to the petitioner.
That is the indication.
Lordship, because other Lordship, others may come up and then
Relief will be reconsidered on the returnable day.
Very
Lordship.
absolutely.
17th August.
Will be reconsidered.
Lordship.
But instead
Matter of continuation of the interim order will be reconsidered on the returnable date.
Lordship.
can it be instead of 24th August?
Okay.
Great.
Lordship.
You provide it within 15 days.
Lordship, Lordship.
2408.
So grateful. Court first.
Okay.
The Lordship has made me free before lunch, Manad. I'm so grateful.
Okay.
Lordship, in this matter, I was supposed to file an affidavit,
Yes.
but the concerned person is out of town. And may I pray that matter may come up next Monday. He's coming this week, I'll file the records.
Okay, Mr. Dr. A. Todi, learned counsel for the petitioner, has sought for a further time to bring the memo of appeal filed by the petitioner before the first of appellate authority on record by your affidavit. The price allowed, leads the case on so. Mr. K. Jain, learned counsel on behalf of the respondent authorities.
You water on
Ye-
behalf of three borough.
Mr. K. Jain,
4, 2, 3, and 4.
you are Miss
You water.
learned counsel on behalf of the respondent 1. And Mr. K. Jain, learned counsel on behalf of Mr. S.T. Kyle, learned senior counsel and special counsel CGST for the respondent number 2, 3, and 4 are present. The prayer made by Dr. Todi is allowed, leads the case on file.
2707.
Much of it.
Much of. Item 15. No, Lordship. This is a very simple petition, but RTI has been filed but not replied. And by that time, petitioner could not appeal the provision. And thus had this petition.
Where you have filed the RTI application?
Not before Director of Land Records and Survey, Miller,
When?
page 10, 12, Miller,
10, 12.
page 13, Miller,
Then what is the provision in the RTI Act?
section 6, Miller.
RTI Act?
Yes.
What does section 19 says?
Section 19, Miller, this is rejection,
Who does not receive any decision?
is appeal provision, Miller.
No, appeal provision is there.
She could not avail Miller because she was misguided some official Miller.
Huh?
She was illiterate person Miller. Petitioner Miller, illiterate Miller she could not avail the appeal. And actually, my lord, she was misled by the official, my lord, concerned office, my lord. Yes, sir.
No, by not filing an appeal within the time period, you have foreclosed your right to prefer an appeal. And in that situation, a writ petition is not the remedy.
No, that's why, my lord, petition is filed.
You file first application before the DLR. This is not the way.
Let me make the observation. In that case, not make the observation. Otherwise,
No, I'll observe that the petitioner will file a fresh application when it close this application. Because after 30 days, expiry of 30
Yes.
days, you have to file a fresh application.
yes, Mr. There was could not avail, my lord, because she was in illiterate and other.
May within.
Yes, may within. Moreover, my lord, there was no communication with the petitioner, my lord, regarding rejection and all these things, my lord.
Or otherwise, you can file an appeal as per the proviso. As per the proviso,
Yes, my lord.
the first appellate authority
Yes.
can admit the appeal after expiry of the period of 30 days if he is satisfied that the appellant was prevented by sufficient cause from filing the appeal in time.
Yes. Yes.
So file an appeal. This is petition is not the remedy here.
No.
When there is a provision for conclusion of delay, to file an appeal. Hard.
Otherwise, my lord, the fresh application will be.
No, it is up to you. I will not observe that. I can make your submission, but there is a proviso. Hard, Mr.
Yes, my lord.
As senior learned counsel for the petitioner. Mr. Bhattacharya, you are for whom?
I am for respond number 1. And only respond.
Okay, the learned counsel, learned standing counsel revenue department for the respondent.
For
Sole
DL.
respondent.
For DL. Yes.
For the sole respondent.
Yes.
First, my lord.
Para. The petitioner has approached this court by the instant writ petition seeking to invoke the extraordinary jurisdiction of this court under Article 226 of the Constitution of India. First of para, the big facts. Leading to the filing of the writ petition are as under, are as follows, comma, the petitioner seeking certain information regarding a plot of land, referred an application, file an application before whom you are filing the application.
Not SBI, my lord.
Huh?
Page 13.
Page 13. State Public Information Officer.
Before the state public information officer, comma, O/O, the director of land records and surveys, comma, Assam, Gauhati, under section 6 of the Right to Information Act 2005 on 10/12/2025. Full stop. With a grievance that after submission of the application on 10/12/2025, no information, comma, as sought for by the petitioner, comma, has been provided to the petitioner till the time of institution of the writ petition. Also, para, Mr. Bhattacharya, learned counsel appearing for the sole respondent, has submitted that as per provisions of section 1 of section 19 of the RTI Act, comma, a person who does not receive a decision within the time specified in subsection 1 or clause A of subsection 3 of section 7, comma, may, within 30 days from the expiry of such period or from the receipt of such a expiry of such period, prefer an appeal to such officer who is senior in rank to the state public information officer. First off, para Mr. And the petitioner has not preferred any appeal under subsection 1 of section 9 and has directly approached this court by the incident petition. Mr. Sinha has submitted, in response, Mr. Sinha has submitted that the period envisaged in section 19 within bracket 1 of the RT Act has already expired and the petitioner has no other remedy. First of para. The proviso to subsection 1 of section 19 has provided that the first appellate authority who is authorized to admit an appeal, may admit an appeal after the expiry of the period of 30 days. If he is satisfied with that the appellant was prevented by sufficient cause from filing the appeal in time. Post of para. In view of the aforesaid provision containing the proviso to subsection 1 of section 19, the petitioner has the remedy of preferring an appeal showing sufficient cause as regards the reason which prevented him from filing the appeal within time. In such view of the matter, that this petition is not entertained in view of availability of the remedy, statutory remedy of filing an appeal in terms of section 19(1), read with the proviso there in terms of subsection 1 of 19 of the RT Act, read with the proviso thereof. So the petitioner is at liberty. It is open. It is therefore open for the petitioner to prefer. Still open for the petitioner to prefer the appeal under section 19(1) before the first appellate authority, showing sufficient cause as to what prevented him from filing the appeal in time. And if such an appeal is filed before the first appellate authority shall consider the reason for preventing the appeal beyond the period of limitation under subsection 1 of section 19, and thereafter consider the appeal if he is satisfied that due to sufficient cause the petition was prevented from filing the appeal in time.
Item 16.
May it please your lordship. Lordship, previously the petitioners had filed a writ petition 4263. This is under the same Zamindari estate as before, your lordship, Coach Begila Zamindari estate. And petitioners have earlier filed a writ petition 4263 of 2025.
How many petitions? Two.
Originally, they had
How many
filed
petitions are here?
earlier. 2018 one was filed, which was subsequently withdrawn.
5 petitioners. What is the first petition?
Lordship.
What is the first petition?
Lordship, the first petition is in page 29 to 35.
29.
Lordship.
2343.
Lordship.
28 petitioners, or how many? 79.
Lordship.
These 5 petitioners were among them.
Lordship.
Okay.
Those were withdrawn due to it being sent, application being sent for consideration. Once the application was being sent for consideration, the 2018 petition was withdrawn, your lordship. Subsequently, writ petition 4263 of 2025 was filed, your lordship, page number 45 to 49, where
Where is the withdrawal?
Page 43.
Yes.
Your Lordship, thereafter, writ petition 4263 of 2025 was filed, wherein through IA Civil 2042 of 2026, interim of maintaining status quo was granted, Your Lordship, on 19/6/2026, recently.
4263 is for what purpose?
Was for issuance of patta, Your Lordship, and for non-consideration of their earlier representations, Your Lordship. Subsequently, interim was not granted there initially in 4263, but thereafter in 19/6/2026 through IA Civil 2042 of 2026, interim was granted, Your Lordship. Lordship, 19/6 order you will find in page 45, Lordship, where interim was granted for DAG numbers mentioned in the schedule of the petition, of this petition, Your Lordship.
Till the next date fixed.
Lordship,
Then that order is continuing.
interim is continuing,
Status quo order is continuing.
Lordship.
So then what is the cause of action for this petition?
Your Lordship, on 9 July 2026, Your Lordship, the petitioners came to know that some DAG numbers, DAG number 349, 354, 361, and 270 have sought to be allotted, Your Lordship, to other private respondents by proposal dated 27/2/2026. This proposal is annexed in annexure number 9, page 51 onwards, Your Lordship. These new DAG numbers correspond to the old DAG numbers of the 4263, Your Lordship, where interim was granted, Your Lordship.
Why? When you see IA order, not the main case order.
The IA mentions the 426.
Say for example, page 57.
Lordship.
What is there? And vernacular, the Assamese version is page 58. This remarks, page 58. Page 58.
Lordship.
This remark is of 7/9/2023. It does not indicate that there is a proposal for
Lordship, the proposal for allotment is on page 51 and 52, Your Lordship.
51.
Lordship, 51 and 52, where the private respondent's name have been given against these new DAG numbers. These new DAG numbers correspond to the old DAG numbers of the writ petition, Your Lordship.
List of individual allotments. Proposal for yes.
Lordship, the allotment is proposed in February 2026. However, the petitioner came to know about it only on July 2026, after the interim was granted, Your Lordship.
What is the status, present status of the proposal?
It is still there, Your Lordship. However, an application has been sent to them after the interim order was granted, Your Lordship.
Yes.
Instruction, what is the present status? Was it earlier also it was not disclosed post?
Heard Mr. I.S. Major Bhuiyan, learned counsel for the petitioners. Mr. N. Bodole, learned standing counsel, Revenue Department for the respondent number 1. And Mr. S.S. Roy, learned counsel for the junior government advocate for the respondent number 2, 3, and 4. So, para. The petitioners, filing number have canvassed that by virtue of the provisions of the Assam land holding within bracket adoption of relationship under the Assam Land and Revenue Regulation, 1886, in the acquired permanently settled estates, bracket close, Act, 1974, read with the provisions of the Gwalpara Tenancy Act 1929, within bracket, since repeal, and Assam, within bracket, temporary settled areas, bracket close. Assam, within bracket, temporary settled areas, bracket close, Tenancy Act 1971. More particularly, in terms of section 4 within bracket 1 and section 4 within bracket 2 of the 1974 Act, have acquired the status of land holders in terms of the parcel of land measuring a parcel of land covered by the following schedule. Page 16.
Page 16, Your Lordship.
These are the lands
These are the lands.
confined to these petitioners.
Lordship.
Okay, following schedule. Para, Mr. Major Bhuiyan has submitted that by an order dated 19/6/2026, passed in IA Civil number 2042/2026, arising out of WBC number 4263/2025, directed the parties to maintain status quo, and the said order of status maintaining status quo is still continuing, is still in operation. Post of para. In this writ petition, the petitioner have projected that the respondent number, who is circle officer? The respondent authorities have proceeded to allot, settle the plots of land mentioned, mentioned in the schedule in favor of the response number 5, 6, and 7 in January or February?
February, Your Lordship.
In February 2026. He has further submitted that the proposal for allotment has not reached the stage of has not reached the final stage of has not yet been approved by the competent authority. Comma meaning thereby the it is his submission that if the proposal is allowed to be finalized, the petition was right under the aforementioned provisions of law will be extinguished. A matter of require consideration, issue notice, returnable on so and so, as Ms. Bordelais and Mr. Roy. 1, 2, 3, 4, no formal notice. Steps upon response number 5, 6, and 7 by speed post within 2 working days from today. Having regard to the projection made in this petition and the submission made that the interim order of maintaining status quo with regard to the loss of land mentioned in the schedule above is still in operation. It is ordered to come in the interim that the parties shall maintain status quo as regards the proposal of settlement of the same plots of land in favor of the respondent number 5, 6, and 7, comma if the same has not been finalized till date, comma till the returnable date.
Highly obliged, Your Lordship.
Both petitions can be tagged. 4263 of 25 may be tagged
Is the
along.
case on surrender?
Lordship, 4263 is already fixed in 27th July.
That may be tagged along.
Then you inform on the 27th July.
21st August, 2108.
5, 6, 7 are to be solved.
Yes.
Obliged.
Item 17.
Mr. Lordship. Firstly, here petitioners has been died due to COVID-19. Accordingly,
Lord Mr. M.R. Khandekar, Learned Counsel for the petition. Authorized revenue and disaster management within bracket relief and rehabilitation branch bracket close department for the response number 1. Mr. Roy, 2, 3, and 4. Learned Junior Government SS Roy, Junior Government Advocate Son for the response number 2, 3, and 4, and Ms. S. Sharma, Learned Standing Counsel, Health and Family Welfare Department for the response number 5. First of the petition, as in this petition, it is stated that the petitioner's husband, late Abu Jahan, died on 1/6/2021 due to COVID-19. And the petitioner is therefore entitled to receive one-time financial assistance or rupees 2.50 lakh as the widow of late Abu Jahan under the Chief Minister's COVID-19 widow support scheme. As the representations submitted by the representation of the petition submitted from time to time have not evoked any response at the end of the respondent authorities, the petition, it is stated that the petitioner is constrained to file the instant, prefer the instant petition. Issue notice returnable on so and so. As so and so appear, accepted no formal notice, extra copies within 2 working days. The respondents are to bring their stands by way of affidavits on or before the returnable.
21st August. Item number 18. Please, Lordship. Lordship, in this case, the marriage officer Gauhati, my lord, has declined to solemnize our marriage, saying that parents should be there before him, my lord.
Which application?
My lord, kindly find 2 applications have been filed. Number 1, that is first application was filed on 20th of November 2025. Kindly find at page 11. And it was delivered on 6/01/2026. That is 6th of January. It was delivered. That means after scrutiny, and it was verified, and from the date of the delivery, the 90 days period is started, my lord. And within that 90 days period, marriage have to be solemnized. They appeared before the learned, before the marriage officer, but he declined to solemnize that marriage, and that parents should be there before him.
No
Thereafter,
recorded,
it was,
nothing in writing.
my lord, no, it is verbally. I
No,
have
you could have
stated,
preferred an appeal.
my lord.
You could have preferred an appeal.
Since there is a violation of fundamental rights, my lord, that
But fundamental, whether it is fundamental right to marry.
because under the statute, there is
What
section
is,
4.
what is
Section
held
4
by
is-
the constitution bans?
My lord,
Whether you have fundamental right to marry or what?
it-
No,
it-
since you are espousing
my lord,
fundamental right to marry, whether it is a fundamental right,
it is.
what does it, what has been held by the Supreme Court in that judgment?
Other-
No, since
Otherwise,
you are making a submission on the basis of what?
otherwise, my lord, section 4 of the marriage, Special Marriage Act
So,
has given,
don't raise the fundamental right at the drop of a hat,
my lord,
right?
my lord,
So you foreclose your right to prefer an appeal
yes, my
after the first application was
rejected.
rejected.
Yes.
Not rejected, Lordship. It
That
has
was-
lapsed.
Lapsed.
Lapsed, 90 days period lapsed.
So 90 days, you could have preferred an appeal, you did not prefer an appeal, so don't hesitate the first application. Now we are into second application.
Second application has been filed.
6/6/2026.
Yes, my lord.
Right.
Yes.
1 month has not expired.
Oh, they have already appeared before.
When
the-
you are 15/6/2026.
Yes, the time is there,
Hmm.
but again, the stand does not change by the marriage officer. He is saying
Marriage
that-
officer.
Yes, my lord.
Marriage
officer
officer,
Gauhati.
Special Marriage Act.
Yes,
Where is that notification regarding application for marriage?
it is
registration,
section
madam?
4.
Huh?
Section,
There, your lordship, regarding the appeal provisions regarding.
No, that is, where is the notification regarding application for marriage registration?
it is,
You should have come up with. Where is it? You two are measures.
yes. And they had appeared before
Special
the
Marriage
marriage
Act.
officer.
Which provision?
My lord, section 4. Section 4 says the requirements for solemnizing this marriage, my lord, under Special Marriage Act.
Where is the notification, madam?
Yes, sir.
And where is the notice of intended marriage?
It is.
Objection
it
to
is
marriage.
Section 5.
Procedure on receipt
Section
of
five.
objection. Powers of the marriage officer in respect of inquiries. Procedure on receipt of objection. Declaration by the parties. Place or information.
My lord, only requirement is that both parties. should
Where is
be-
the marriage officer?
It is, I have made him party as respondent number 2.
Marriage officer is different authority
So,
than sub-register.
Respondent number 3. It is sub-registered.
No,
Guwahati.
where from you are saying that a marriage officer is sub-register?
My lord, generally here it is marriage is solemnized before the sub-register. And he acting as marriage officer.
Come to section 3.
No.
Read subsection 1.
Section 3, my lord.
Yes.
Subsection 2, my lord.
1.
1. For the purposes of this act, the state government may, by notification in the official gazette, appoint one or more marriage officers for the whole or any part of the state. Second,
That is Jammu and Kashmir.
yes,
Right. Where from you are saying
my lord.
that sub-register is a marriage officer?
Because petitioners appeared before the sub-register, Gwalbara, my lord. And
Yes, marriage officer is the sub-register.
Marriage officer is not the.
Sub-register. Sub-register.
Sub-register.
To my knowledge, he may not be the sub-register.
There must, huh?
If you are saying that, I will ask.
Lordship.
Since you are making submission, get the instruction from respondent number 3.
Yes, your lordship.
From your submission, it appears that marriage officer is the respondent number 3.
yes,
So get the instruction.
Lordship.
What you are saying that he is not inclined.
yes, my lord. He has a decline to solemnize the marriage.
I have to take
Third.
instruction.
Mr. S. C. Das, learned counsel for the petitioner. Ms. N. Bodole, learned standing counsel, Revenue Department for the respondent number 1 and 2. And Mr.
Yes.
S. S. Roy,
Sub-register.
learned junior government advocate Assam for the respondent number 3 and 5. Full stop.
Yes.
The petitioners are married, are majors, and they intended to solemnize their marriage under the provisions of the Special Marriage Act 1954. Full stop. In that connection, they submitted an application for the service, notified public service, within bracket, quote unquote, application for marriage registration, unquote, on 6/6/2026. Before the, in the designated portal, and as per the details uploaded in the designated portal, the application has been duly delivered on 15/6/2026. Para. As per the office memorandum dated 12/4/2013, wherein general guidelines regarding standard procedure to be followed to provide the providing for marriage certificate, in case of intended marriage, persons eligible to enter into marriage, within bracket, bride and the bridegroom, would issue notice of intended marriage to the marriage officer with signature witnesses in the prescribed form and deposit the necessary fees as applicable. Full stop. After expiry of 30 days from the date of notice and within next 60 days, both the parties would appear before the marriage officer for solemnization of their marriage. Full stop. On submission of a declaration under section 11 of the Special Marriage Act 1954 before the marriage officer with 3 witnesses, comma, the marriage officer, after taking the declaration from the bride and the bridegroom, has to administer an oath by them in presence of 3 witnesses and has to issue a marriage certificate with signature of both the parties along with 3 witnesses. Full stop. Para. As per the provisions, Mr. Das, learned counsel for the petitioner has submitted, petitioners have submitted that when the petitioners appeared before the marriage officer, comma, the marriage officer has declined to complete the formalities and to issue the marriage certificate in terms of the provisions of the Special Marriage Act 1954. Full stop. Para. As per the provisions of the Assam Right to Public Services Act 2012 as amended, comma, if a designated public servant like the marriage officer for the notified public service, issuance of marriage certificate does not extend the notified public service within the stipulated time period, comma, he has to pass a region order in writing for not extending the notified public service to the applicants. Full stop. Para.
Lordship, the notification is 23rd of December 2019, whereby the deputy registrars, senior sub-registrar and sub-registrars are appointed as the marriage officer.
As the respondent number 3 is a marriage officer in the case in hand, comma, Mr. Roy shall obtain instruction from the respondent number 3 as to why the notified public service has not been extended to the petitioner. To obtain such instruction, Mr. Roy has sought for a week's time. First of place the case accordingly on suits.
Notification is
Since you have said on the basis of notification, I am recording.
yes.
No issue. He is a marriage officer. So let him apprise this court why he is not extending the service or why he is not passing the region order as required.
Date may be,
I've said 1 week. Court master will give the date.
yes.
31st July,
Obliged.
3107.
Text.
Item 19.
Could you by any good dispose of it?
My lord, I'm the owner of my plot of land of measuring 1 acre 1 lesson. And out of this, 14 lessons has been.
You approached earlier.
My lord.
Huh?
Lordship,
Page 37, Lordship.
Page 37.
The last portion, my lord, Lordship was already been.
That number 26 is not required and not required by the road authorities, national highway authorities. But the respondent number 2 and 3 in this instant petition.
Go slow, go slow.
My lord.
So your dark number earlier you hesitated that dark number 26 has been acquired.
My lord.
Then from the notification it
is not required.
It did not emerge.
My lord.
That land was under acquisition. So your repetition was dismissed.
My lord.
Closed. So now with what grievance you have come again?
My lord, I have come is because the that number 26 is not required or required by the national highway authorities.
I am not understanding.
My lord, but the present respondent number 2 and 3 has broken down my properties. Two boundary walls, 1 mandir, and destroyed the plans.
Kindly see the pair number 1 of the page 13.
Okay, paragraph, page 37, fourth paragraph.
My lord.
Fourth paragraph.
Four paragraph.
Paragraph number 4.
Four.
Now, on that basis, he is making, submitting this.
And even then, Lordship, pair number 1, Lordship, may kindly see. Page 13, Lord.
Page 13.
13.
Some liberty is there.
No, yes, Lordship, liberty is
If any
given.
such area
But-
under DAG number 26 is brought under the purview of the land acquisition process, the petitioner is at liberty to seek appropriate remedy as permissible under the law.
Lordship.
Now he is saying that boundary wall has been demolished.
Lordship. And the pair number 1, Lordship, that
Destruction. What destruction?
My lord, then page number.
Which paragraph?
My lord, page number 27
27.
or 27.
27. Let us see 27. Okay, I'll read the vernacular Assamese.
Connection number 4.
Raji
Resolution number 2.
is the navigator number Kukuma.
I have received the compensation of Jirat.
আবেদনকে উত্তর দিয়ে তো মূল্য পাওয়া দেখা যায়।
হাজৰিকাৰ নহয়, কিন্তু লিষ্টখনত ডান্স আছে।
English নাই নহয়।
এইখনত লিষ্টখন নাই লোক।
This is a disputed question of fact.
Lordship.
চক্ৰ বিষয়া, ছয়গাঁও ৰাজহ চক্ৰ for 26, DAG number 26, right? You have already received Jirat.
But I have not.
1 minute.
My lord.
1 minute.
My lord.
You have already received Jirat. কিন্তু আবেদনকাৰী ঘৰত থকা অধিগ্ৰহণ হোৱা অংশ বিস্কুট ফেক্টৰীটো জিৰাত লোৱা সময়ত বিভাগীয় বিষয়া উপস্থিত নথকাৰ বাবে বাদ পৰা দেখা যায়। তদন্তকালত উক্ত বিস্কুট ফেক্টৰী থকা দেখা যায়। Yes, whether this has been brought into existence after notification or before notification. Sometimes in many cases, we have seen constructions are made after immediately on the next day of 3A notification. Overnight, then a few cases. Nowadays, the authorities are also intelligent. They take drone pictures with all the dates and time. And 2 cases, it has come on record. Just on the date of notification by the drone picture, there was nothing. Immediately on the next day, structures. I have dismissed few. Let us see this one also, how it emerged. Heard Mr. S. Das, learned counsel for the petitioners. Biscuit factory has come up.
My lord, the biscuit factory.
So you have to produce
my lord
documents.
My lord.
When you got the license for biscuit factory?
But yes, all licenses are there, my lord. But registration.
Question is date.
Yes, my lord. I will file in the next evidence.
Because this forum is not to be used
Even
for
then,
undue enrichment.
even then, Lordship, my lord, in this matter, Lordship, the National Highway Authority has not made a party yet because, my lord, suppose Lordship was given any direction.
They have cleared the earlier petition, my lord, in 3360. This honorable court has passed the order on 25th June, my lord, already. That's why the National Highway Authority has not been included.
Why?
But the payment have to be made. Lordship.
But National Highway, they have already.
Who has damaged that?
They declared.
Okay, question of non-implement of necessary party dismissal.
My lord.
Because who will pay? Central government.
My lord.
Deputy Commissioner is not going to pay. On the earlier petition, you have made IDCL a
But
party.
they have not acquired, my lord. According to them, they have not acquired.
But who will pay the price?
My lord.
Mr. Das, you always come up with some shortcomings. Make competent authority land acquisition. Kala.
My lord.
Right? One party.
My lord.
NHIDCL. Another party.
My lord.
And central government. Ministry of Surface. third party. They will pay. They have the money.
My lord, but in earlier petition, writ petition, my lord, they kept.
Oh, Mr. Then I am dismissing it right now. They are on the basis of their submission. Because all acquisition is under National Highway Act.
National Highways. Act.
It is clear.
My lord.
Again, I dismiss it, or
No,
you
no.
want to withdraw this with the liberty to file affairs?
Yes, my lord. Yes, my lord.
But I will liberty to file a fresh.
Previous dismissal has clearly recorded
My lord.
the acquisition is under National Highways Act.
Right.
Kala is there, National Highway is there, central government was there. Make them party. Mr. Das, learned counsel for the petition, has submitted that due to inadvertence, necessary parties, some of the necessary parties could not be implemented as party respondents in the instant petition. Post of Mr. And Ms. Enbodule and standing out the revenue department for the respond number 1.
I am for 2 and 3.
Respond number 1 is also defective.
Also defective.
Everything is defective.
Land acquisition, lordship, they have earlier matters also they have made the same.
Mr. Das,
My lord.
file a better petition. Next time I'll impose cost while dismissing it. And so nobody can represent. There is no entity like respond number 1.
Right.
Mr. J. Hendick, learned counsel, junior government advocate for the respond number 2 and 3, has submitted that the petitioner's claim is for Zirat competition is relatable to the national, relatable to the provisions of the National Highways Act 1956. And in this petition, the respondent, none of the respondents is an authority under the National Highways Act 1956, and this petition entails dismissal in limine due to non-implement of the necessary party respondents. Post of para. At this stage, Mr. As in view of the submission made by Mr. Das, learned counsel for the petitioner, the petition is dismissed on withdrawal with the liberty to file a phrase with proper details and with implement of necessary parties. Again, if you come up with a defective, I'll again dismiss.
Item 20.
May I please? This is regarding, my lord, sale permission, NOC from the, my lord, competent authority. And
NOC
NOC, my lord, for sale deed, my lord.
sale deed. Okay.
My lord, I've applied, my lord, before the authority, my lord, the land in questions are not surveyed as of now. So, my lord, competent authority advised me to apply in the old form, which is prescribed. Accordingly, I applied page 27, my lord. My lord, my lord. original-
27.
Yes. On, my lord.
Okay,
11
this is manual.
Manual, man. Manually I applied.
Yes, Karimganj, no online,
In Patarkandi, some areas, this is not.
no online.
Lordship, let me take instruction regarding.
Tomorrow. Otherwise, you'll dismiss. Sorry, I'll dispose of the repetition to pass a order under section 21A.
Yes, my lord. That may be, my lord.
Or if it is online, then I'll direct the petitioner to file an application online.
Yes, my lord.
If it is manual, I'll dispose
Yes, my lord.
under section 21A
Yes,
to either allow NOC or to pass a regional.
yes, within 30 days as prescribed, yes.
Or if it is online, then you have to file the application as per the proper
Yes, my lord.
procedure.
My lord,
Tomorrow,
See, tomorrow.
JMA Chaudhary.
Okay.
Yes, only instruction, manual or online, offline or online.
yes.
That's
yes,
all.
Yes.
Yes, madam.
Yes.
Either offline or online, online.
that particular from that particular Patarganti.
Heard Mr. J.M.A. Chaudhary, learned counsel for the petitioners, and Ms. Ann Bordoloi, Revenue 1, J. Hendrick 2 to 5. Post of. The case of the petitioner is that they had submitted an application for no objection certificate for transfer of lands under section 21A of the Registration Act, comma. Have you annexed the amendment?
Manually.
No. Amended Registration Act so and so, comma, as amended by
Registration Act 2009.
Registration Assam Amendment. What is it? Registration Act 1908,
Yes.
comma, as amended by the registration within bracket Assam Amendment, bracket close Act 2009. Full stop. It is the contention of the petitioners that which paragraph, Manuel, you have said?
14, Melo. Paragraph 14. Page 7.
As official survey operation relating to the concerned area involved, comma, involved in this writ petition, comma, has not yet been completed, comma, the online process was not available to the petitioners at the time of submission of the application on
My lord, 11/2/26.
11/2/2026. And accordingly, comma, an application to the offline mode seeking issuance of no objection certificate was submitted before the competent authority, comma, which was received, acknowledgement of which was received as document number 40A. Post of para. Both Ms. Bordoloi and Mr. Hendrick have sought time till Wednesday to obtain instruction whether for the area in question, the application for no objection certificate is to be submitted in the offline mode, comma, in view of non-availability of submission, non-availability of, in view of non-availability of the facility to submit online application.
Yes.
Please the case on sir.
What if our name may be reflected in
The name of Mr. J. Handy.
No,
and
Lordship, J. Assam Lordship has not been reflected in the list. No, that's why that.
Okay, the name of government advocate, land government advocate, Assam is to be reflected in the respondent side in the process.
2207, 22nd July. Item 21.
Same, but only thing is that in item 21, my lord, interreligion.
Whatever, order has to be passed.
Yes.
Same document number,
My lord, same, everything same, my lord.
document A.
Yes, 48.
Para?
Para 5, my lord. I have stated. Para 5 here.
Para 5. Document 48, 11/2/2026. Team. How many petitioners?
My lord, 3.
3.
One and two are-
Land transfer, NOC,
NOC.
21A.
Yes. Okay.
Interreligion.
Whatever, you have to pass the region order or to reject the application or to allow the application.
Both are fixed on Lordship.
Where is the
22.
name of government advocate?
Item 22.
May I please your lordship? Lordship, this petition is related to blanket freezing of the bank account of the petitioner.
Heard Mr. M. Jamal, learned counsel for the petitioner. The petitioner maintains a savings bank account. Number. Para 3. At Sorvok branch. State Bank of India, District Borpeta of the State Bank of India as per number 3. Bracket. The petition has contended that the respondent bank of SBI, State Bank of India authorities have placed debit freeze instruction on the said savings bank account of the petitioner pursuant to receipt of 2 separate cyber crime complaints lodged in a national cyber crime reporting portal within bracket NCCRP. The petitioner has contended that though the total thus fraudulent amount suspected to be the total fraudulent amount involved in the said 2 cyber crime complaints are suspected to be or rupees 64,22,000 and rupees 52,15,682 respectively, comma, only sums of rupees 22,000,
3,264.
264.21 and rupees 3,000. That is rupees 3,264.21 stood credited to the savings account of the petitioner, and therefore any action on the part of the respondent State Bank of India authorities and the investigating authorities placing debit freeze instruction over the said amount of rupees 3,264.so is an unauthorized action according to the petition. Issue notice returnable on so and so.
Otherwise, this is a covered.
What covered?
There is already a judgment and order passed by coordinate bench of.
Without notice, how can it be?
Lordship.
It is not a case of covered. The petitioner shall supply a copy of the requisition along with an annexure to the Deputy Solicitor General of India within 2 working days from today for service of notice upon the respondent number 4. Steps upon speed post within 2 working days.
Obliged.
2108, 21st August. Item 24.
May it please your lordship. My lord, I had sought certain information under RTI Act before the respondent authorities. and the information has been denied, taking the plea of
Who is the SPIO? Response number
4.
then
And
preferred
this-
appeal.
It has been denied by taking. the
Preferred
plea-
appeal.
Preferred appeal also upheld the decision of the SPIO. And consequently, my lord, second appeal was there. It was also dismissed. And therefore, I am before your lordship. Now, the plea has been taken in denying the information is.
Issue notice at this stage.
Yes,
That much.
yes.
You are
For response number 1.
only one.
Only one.
Heard Mr. S. Dr. Leonard. Senior counsel listed by Mr. E. A. Kamil. Why it will be, it is preferred before this court?
My lord,
Because just because the SPIO is here.
yes.
Learned counsel for the petition. And Mr. Kakoti.
S. Kakoti.
S. Kakoti, learned counsel for the response number 1. First. What is the decision of the Central Information Commission?
That will be at page 80. Relevant portion will be at page 80. The operative part will be at page 81. Serial 9.
Salma Hassan. For the court's curiosity, what do you do?
Well, she's an advocate by occupation.
Advocate. The applicant seems to be wasting time in the law profession. Applicant seems to be. More than what can be seen. Issue notice, returnable also, 4 weeks. Steps by registered post. The petitioner is agreed by the nature of information. I'll keep the maintainability issue open. Because some are classified information seems to be.
No, they have not said it is
No,
classified.
we'll examine. We have the jurisdiction
Yes,
under the, to decide on the RTI Act.
yes.
Seems to be more than meets the eyes. Which cannot be refuted by Mr. Datta also. Agreed by. The order dated 8/9/2025 passed by the respondent number 2 under section 19 within bracket 3 of the Right to Information Act, which has affirmed an order dated 14/8/2025 passed by the first appellate authority under section 19 within bracket 1 of the RTI Act 2005 and an order dated within bracket first appellate authority, that is within brackets respond number 3, and an order dated 13/8/2025 passed by the SPIO within brackets the respondent number 4. The petition has instituted the instant litigation. Issue notice returning. The issue of maintenance of the repetition is kept open for consideration.
Probably the order will be 18/5/2026 by the second appellate authority. 18/5/2026, annexure 6.
18/5.
18/5.
18/5. Prothom to 18/5, second to 3/9/2025, third to 13/8/2025.
Yes.
25.
Yes.
May I please the Lord. Here, my Lord, account has been freezed, my Lord, and there is no cyber case in this case. My Lord. And no information has been given why they have, my Lord.
Heard Mr. R. Ali. You appear for bank.
For 2 and 3.
Heard Mr. R. Ali, Learned Counsel for the petition, and Mr. M. Sherman, and counsel for the respondent number 2 and 3. Poster. The petitioner maintains. Savings bank account, savings bank account number, where 3. At with the respondent number 3. Poster. The petitioner or said bank account has been kept in the freeze condition without any prior intimation, stroke notice. Poster. It is a case of the petition that despite repeated approach, says the respondent bank authorities have not assigned any reason for keeping the bank account of the petitioner in freeze condition, and Stop. Hence the writ petition, issue notice returnable on so and so. The, as Mr. Sharma, 2 and 3, no formal notice, extra copies, 2 working days. Baki, Deputy Solicitor General of India, 2 working days, for respondent number 1. Huh? Which is the respondent bank authorities are to bring their stand on the affidavit by the returnable.
24th August, 2408. Item 26.
May it please your lordship. The matter pertains to land acquisition in Umrangso, Dimahasa, lordship. About 9,000 bighas, lordship, of land was acquired by the council, and then it is supposed to be handed over to cement companies for land for limestone mining.
These 17 petitioners
Yes, lordship.
are owners of what parcel of land?
Lordship, their traditional.
We are not concerned with 9,000
Yes,
bighas in a
lordship.
writ petition under Article 226.
Yes, lordship.
Because this is not a PI.
Yes, lordship.
No, what these petitioners,
Lordship, with regard to there are some
tell me,
petitioners 1 to 4, lordship. They are,
what are the areas of land?
lordship, all of them have different areas of land, lordship.
Tell me, what is
Yes,
precise land? We are not in PIL, sir.
Yes, lordship. Yes, lordship.
Where are their lands?
Lordship, annex.
Don't espouse the cause of 9,000 bighas.
No, lordship, no, lordship. Only for
Yes,
other individual
where are,
land.
what are the areas of land?
Lordship, Annexure 2, page 40.
Not Annexure 2, where is the body of the writ petition? We will not calculate by going to Annexure 2.
Lordship.
Am I clear?
Yes, lordship. Yes, lordship.
We will only see the individual causes of these 17 petitioners.
Yes, lordship.
We are not into 9,000 bighas.
Lordship.
Right?
Lordship.
Now, where are those? In the body of the writ petition.
Lordship, in the
That
body.
petition number 1 is the owner of this much of land under this pattern number, tag number.
Lordship, that have not given the.
Oh, will not broaden the scope of the litigation.
No, lordship.
Where are those?
Only on the individual line only have.
Where are those? Where is the table?
Lordship.
We are not going to calculate here from
Yes,
the annexers
Yes, lordship.
running into 100 pages.
Yes, lordship. Lordship, actually, there is.
Where is the description?
Lordship, para 4, lordship, I have.
Where are the descriptions, sir?
Lordship, all
How
of them
much
don't have.
petition number 1? How
Yes.
much petition number
Lordship,
2?
Lordship, all of them don't have pata land, lordship. It is
What kind of land then?
Lordship, it is under the house tax, they pay house tax.
So
It
what
is not
areas?
Lordship, area is not calculated, lordship, in the village, lordship. It is never calculated. It is this.
Then we will issue rule only.
Lordship may consider.
With these particulars,
Yes, lordship.
petitioner do not know what areas of land they have. They don't have any documents. They are espousing 9,000 bighas.
No,
Right.
lordship, not 9,000 bighas, lordship. It is only the context that it is part of the 9,000 bighas, lordship.
No, that is synopsis has harped on it.
Yes, lordship.
Is it not?
Because
Because you don't know the areas of your own land.
when they acquired
See,
the land.
Mr.
Council,
Yes, Lordship.
we are not into PIL
Yes,
jurisprudence. PIL jurisprudence is before division bench.
Yes, Lordship.
Nothing.
Lordship, may kindly consider.
In the prayer also, nor in the synopsis, nor in the body. Somewhere in the
Specifically,
annexers.
Yes, Lordship.
We are not.
Specifically, it's not given, Lordship. It is true, Lordship.
Come up with better thing that I am in possession
Yes, Lordship.
of 10 bighas.
Yes, Lordship.
Petition number 2 is in possession on certain,
Yes, Lordship.
on the basis of certain claim,
Petition
right?
number 2
And
is
make it a
in
tabular form
Yes,
that we in together,
Yes,
7 petitioners are in possession of say 70 bighas of land or 100 bighas of land.
Yes, Lordship.
But you are saying 9,000 bighas of land. So everything was, no, we will examine only the petitioner's cases.
Yes, Lordship.
If you want to
Our prayer
go
is
for in a broader spectrum,
Yes, Lordship.
go to the PIL jurisprudence before the division bench.
Lordship, I'm here only on the
No,
individual
but
basis.
body of the petition, nor the prayer, nor the synopsis, nothing.
Lordship, may kindly consider Annexer 19, Lordship.
Will not examine.
Lordship, may,
When there is no pleading,
Lordship.
what areas of land you are in possession.
Yes, Lordship. But Lordship.
We are not going to examine 7,000 bighas by that
No,
way.
No,
What
Lordship.
cannot be done directly cannot be done indirectly.
Yes, Lordship.
So just because 9,000 bighas, no.
Lordship,
I'm sorry.
Only.
I'm
Annexer
sorry,
19.
Mr. Kathar.
Lordship, may kindly-
Make precise case.
Yes, Lordship.
You have ditch mass of areas. 17 persons cannot be owner of 9,000 bighas of land.
Yes, Lordship.
They must be having possession or occupation of 100 bighas or 200 bighas
Yes, Lordship.
maximum.
It is-
Don't espouse the cause of 9,000 bighas.
It is specifically not given in the
Not
pleadings. Lordship.
given,
That
sir.
is true.
I have seen now,
Yes,
just, I have not seen, but I have just seen going through the brief.
Yes,
Right now,
Lordship.
this is not the way.
Lordship, may I kindly take Lordship to Annexer 19, Lordship?
I'll not, why I'll see? Why I will see?
There was a resolution by the
No, petitioner
Lordship.
have to set up their precise case that they are in occupation.
Yes, Lordship.
Will not examine unless they make a statement on oath
Lordship.
that we are in possession of this much of areas of land which are sought to be or which have been brought under the purview of acquisition.
Lordship, because it is a non-cadastral area, Lordship, that was the problem.
But where is the claim?
The specific.
You cannot be in occupation of 9,000 bighas.
No, Lordship, we are not seeking that, Lordship.
Then issue rule, hard. Mr. J.I. Kathar, Learned Counsel for the petition.
AI Katha, Lordship. AI Katha.
A.I. Kathar, Learned Counsel for the petitioners. Mr. Because we are not going to roving inquiry.
Lordship.
Anybody? Central Government Council?
I'm for respondent number 11, NIPCO.
Who are you?
NIPCO.
NIPCO.
Respondent number-
Anybody?
And of 2, 4, and 5.
2, 4, and 5.
Not only 4, but 5 and 7. 2, 5 and 7.
Mr. J. Hendrik, Learned Junior Government Advocate, Assam, for the respondent number 5 and 7. Mr. S. Borua,
Or 6.
Learned Standing Council, Pollution Control Board, Assam, within bracket PCBA, for the respondent number 6. Autonomous Council? You have not served notice or what?
Serve notice, Lordship.
Okay.
House and Lordship.
None has appeared for the respondent number 1 and respondent number 3 and 4. Today on call, though the names of the Learned Council for proceed respondents are reflected in the cause. The petitioners, 17 in number, have joined together to institute this writ petition, stating that they have a common cause of action to espouse. Because although the petitioners have stated in paragraph 4 of the writ petition
that the petitioners, petition number 1, 2, 3, and 4 have whole pattas, and the petition number 5, 6, 7, 8, 9, 10, 11, and 12 names of the petitioner are reflected in the yearly revenue list. The petitioners have not disclosed about the areas of land under their, either under their names or under their occupation or possession. First of para. In this petition, the petitioners have assailed, have raised a grievance that the respondent authorities have resorted to unlawful action, stroke allotment of a parcel of land measuring about 1270 hectares within bracket 9,000 bighas of land in and around Boro Lakindong, Choto Lakindong, Thar Bhelangso, Sikil Langso, and adjoining villages, along with a proposed 320 poster. The petitioners have also assailed about issuance of mining leases and initiation of tender processes. Poster. It is the case of the petitioner that there has been no lawful acquisition of the lands, no proper SI, no public hearing, no valid consent of the affected families, and no award proceedings under the RFCTLA-RR Act 2023. And compensation amounts, compensation list of persons eligible to receive compensation have been prepared, and crores of rupees were directly deposited to the selected accounts of certain persons without transparent identification of the genuine landholders from the in the in a petition under Article 226, in a petition under Article 226, it is the individual cause which is to be espoused. First of a petition under Article 226 cannot be in the nature of like post of issue rule returnable 6 steps. So what did you no extra copies. Steps are the remaining responded by speed post within 2 working days.
27.
Please, your lordship, my lord, the petitioners are grandchildren and great-grandchildren of the original Pattada. Now, the
Let me read the synopsis. How many petitioners?
3.
You are from which district? Dhubri?
Dhubri.
So you are agreed by the proposal and passed in favor of response number 6?
Yes, and my lord.
Yes. Response number 6 as it
Six, yes.
Lordship, in case number 24, Lordship, demand notice.
That has been deposited, they are saying.
No, how many lands occupied, possessed by the
Huh?
petitioner, it is not clear, Lordship. Page number 23 type of here.
Page number 24.
24, yes, Lordship.
Right. Within 9 days, you have to pay,
Well,
and according to them, land revenue, that is patta number was there, Jami was there. How much is the land?
6 biga 9 katha.
If it is 6 biga, let us go by their content. 6 biga, 2 katha, 9 lessa. And the patta number.
Here also, my lord, in page 24 also, my lord, the against the endorsement Jomi, it is 6 biga 2 katha 9 lessa. On the left hand side. And
so they have said that they have deposited.
Page 26 is the receipt.
They have deposited. So after that, it cannot be outrightly allotted in favor of the petition. Response number 6. Heard Mr. S. Dr. Learned Senior Counsel, explained by Mr. H.R. Ahmed, Learned Counsel for the petitioner. Petitioners. Mr. Authorised, Revenue 1, H.K. Hazarika 1 and 2, Junior 1 and 2.
3, 4 and
H.K. Hazarika Learned Junior Government Application for response number 3, 4 and 5. Post of para. The petitioners, comma 3 number, comma, have stated that they are legal representatives of late Ziar Mondal and Mojitullah Haji, comma, who were the absolute owners and possessors, who were the absolute owners of a parcel of land measuring 6 bighas, 2 kathas, 9 lessas, comma, covered by periodic patta number 98/117, situated at village Kathaldi, Part 1, comma, Bilakipara Revenue Circle, District Dhubri, Assam, subject plot. Post of. On 8/11/2013, comma, a demand notice was issued in the name of Mojitullah Haji and others, demanding an amount of rupees, or demanding an amount of rupees 819.14 as area land revenue for the period 1995 to 2014, within a period of 9 days. Post of. The petitioners have stated that the said demanded amount was deposited on 15/11/2013. Post of. Yet the revenue authorities recorded the subject land as government khas land by creating new DAG number 907, 909, etc. Despite repeated approaches from the petitioners for correction of the land records after deposit of the area revenue. Post of. Para, the cause of grievance of the petitioners, comma, raised in this writ petition, comma, is that out of the subject land, comma, the respondent authorities have now contemplated to allot an area of land measuring 4 kathas created under new DAG number 907 and 909, which is part of the subject land, in favor of the respondent number 6 on the premise that the respondent number 6 is a person who has been evicted due to acquisition of land for a proposed power plant project at Sirakuta area, right? Issue notice returnable on so and so, as so and so appeared accepted. No formal notice, extra copies 2 working days. Steps upon respondent number 6 by speed post within 2 working days from today. Having regard to the projection made, this court is of the primacy view that the petitioners have been able to make out a primacy case for an interim order. It is accordingly it is ordered, in the interim, that any process of allotment stroke settlement of the area of land and the DAG number, new DAG number 907, 909, stated to be created out of the subject land, in favor of the respondent number 6 shall not be proceeded further till the returnable date.
Much of that. 2408, 24th August. Item number 28.
May it please, my lord. Well, petitioner is agreed by the inaction on the part of the respondent authorities in acting upon the representations filed under the provisions of Assam Panchayat Constitution rules, my lord. My lord, the last Panchayat election in the state of Assam was held in 2025 pursuant to election notification issued. Lordship will find that at page number 15.
So respondent number 6 is
7.
Disqualified under what provision?
My lord, due to violation of the two-child norms.
11 section 111.
Section 111 subsection 2 due to violation of the act, my lord.
2A.
2A. Violation of two-child norms, my lord.
Okay, heard Mr. T. Chakraborty, learned counsel for the petitioner. You are a voter or a contesting
Voter,
candidate?
my lord. Voter.
Voter.
Voter. And
Not a contesting candidate.
not a contesting candidate, my lord. I have prayed for a writ of quo warranto as well as a writ of mandamus to accept.
Ms. N. Boral and Standing Council, Panchayat and Rural Development Department for the respondent number 1, 2,
5 and 6.
5 and 6. Mr. H.K. Hazarika. R. Dubey, Land Standing Council, Assam State. Why you are hiding there? Assam State Election Commission for the respondent number 3. H.K. Hazarika, Land Junior Government Advocate Assam for the respondent number 4. Okay. The petitioner, an elector in the Irua Gaon Panchayat District, Nagaon, has instituted the instant writ petition on the ground that the respondent number
7, my lord.
7, who has been elected as a ward member. Ward member or
of
what?
Anchalik Panchayat.
Okay.
As
As a member of Hingimari Anchalik Panchayat in the Panchayat general election held in May
My lord, held in May 2025.
2025 is not eligible to continue as such member as he incurs the disqualifications under section 111 2A of the Assam Panchayat Act 1994 as amended. Full stop. The petitioner has stated that despite submission of representation by him or her,
Him, my lord.
by him,
Yes.
before the deputy commissioner, respond number,
My lord, first submission, first.
deputy commissioner is the authority.
Yes, yes, deputy commissioner. It was routed through, my lord, the member, executive member.
Before the respond number 4 on 23/7/2025
And the.
and 30/07/2025.
Yes, my lord.
The respond number 4 has not initiated any action to cause any inquiry and for disqualification of the respond number
7.
7 till date. Agreed thereby, the petition has preferred the written petition. We should notice refundable on so and so. As so and so appeared. No formal notice, extra copies. Steps upon respond number 7 by speed post within 2 hours.
Obliged.
24th August.
Deeply obliged.
Item 29.
Bank freeze.
Yes, your lordship.
Without looking at the repetition, seeing Mr. Sharma, I can understand. Heard Mr.
Syed Arshad, SB Arshad.
SB sir. Petitioner. What was the previous item? Bank fraud?
It is 25, your lord.
25 on itake likhi dibo. Canara Bank again?
Yes, 20.
Okay. M. Sharma, 2-3. HK Hazarika, 4 and 5. Account number, para 3. Bhopal.
Yes, your lordship.
How he has come here?
But your lordship, account has been freezed by Hatigam police station.
Oh, Hatigam, mister. Come here. Your instruction. Okay. The petitioner, who is a resident of Bhopal, Madhya Pradesh, has instituted the petition agreed by an instruction to keep his savings bank account number para 3 maintained at Bhopal Nehru Nagar branch, Bhopal, Madhya Pradesh, in debit freezed condition on the instruction of the respondent number 4. Any cyber complaint?
Yes, 5 is the cyber superintendent.
Para? Annexer?
Your lordship, respondent number 4, officer in charge, Hatigam police.
Which annexer?
Your lordship, we have not received any form of.
Some statement you have made.
Your lordship, we have approached the Hatigam police station regarding the brain freeze.
Which paragraph?
Your lordship may refer to page number 5.
Page number 5.
Yeah, page number 5, 7. Para 7.
Okay. The petitioner stated that on inquiry command, the petitioner has come to learn that the debit freeze instruction has been placed, has been purportedly issued under section 102 CRPC/106 BNSS in connection with an alleged cybercrime complaint lodged before the Hatigam police station, which has been for a suspicious transaction amounting to rupees 899. Post about Mr. Sharma. and Mr. Hazarika have short time to obtain instruction in the matter issue notice returnable on so and so. As Mr. Hazarika Sharma represents so and so, no formal notice, extra copies. Step 7, the respondent number 1 by speed post, we need to work in this from today. The respondent authorities, the respondent number 225 shall bring their stand on record, stands on the record by way of affidavits on or before the returnable date. The respondents shall traverse whether the debit freeze instruction has been made only on the basis of the suspicious transaction amounting to rupees 899 only, or there are other complaints of regarding suspicious transaction for some other amount.
Please to be obliged.
What is GNM, GSM name has not reflected in
The name of Planet Government Advocate Assam is to be reflected in the respondent side the causes.
2408. Item 30.
Me, all the directors of the board and the chairman,
Board of Directors,
all has opposed this.
Cooperative Society.
Cooperative Society.
Okay.
My lord, may I take your lordship to page 102? Our first AGM was held on.
Who has passed this order?
My lord, this order has been passed by Assistant Registrar Cooperative Society, Office of the.
Just let me read it. Yes.
My lord, against this order, I preferred an appeal and the order has been passed in 108.
You are Board of Directors.
Board of Directors. All the directors has approved this.
108.
108. On preferring the appeal, this order was passed.
I'm not understanding anything. First, explain 103 first.
103. 102.
10, I read always the original one. What?
But here the
Even
date,
if it is not illegible, I always read.
original. But the date is given wrong. It is 26, 19th May 26. It is
Okay.
not 25
Okay.
because that will your lordship will
Okay.
get it from the final. Here, my lord, the issue.
Peruse but let us understand, peruse the letter received from Assistant Registrar of Cooperative Society. Issued on 27 to 2026. What is that?
My lord, that reference, your lordship will get it at page 99. 99.
99.
90. Reference, ARC letter.
Holding of so and so, chairman, first March, okay. This is 99.
Page 99.
Not, but that is 27 to 2026.
My lord, reference has been given of 27 to 26.
Uh-huh.
And this is 11 March.
First letter.
That's
That 27 to is available.
No, my lord, that was the official communication. My lord, in pursuance to that 27 to 26 order, this 11th March order was.
Just a minute, which refers to stated as per information received from the registered person societies. Seal sort. Office mentioned that this office was informed that for the period.
In reply to that, my application is at page 100.
100. Okay, now I understand. And the letter there is so and so received from Ayubuddin Laskar. You are Ayubuddin.
Mal.
Okay. Whereas it is on record that last election, AGM of the society was held on so and so. But the matter got sub judice on, and finally the approval of the proceeding of the sale was accorded by only on 13/9/2024. In compliance with the order of the so and so of the so and so. Therefore, the society was not in a position to hold a statutory annual general meeting for a year within so and so. However, it has been revealed from the letters of the ARCS and the society failed to hold a so and so. Therefore, so basically it is regarding non-holding of AGM for the year 2024-2025 within 39/2025. That is the reason. And he passed the order under 41(6). One-man committee to hold the election and manage the affairs in a period of 90 days.
That is the crux.
Crux.
My lord, can I take your lordship to sum up the background of the fact?
No, what is the next? Let us see, then I'll see the background. What is the next order?
My lord, then the order is, my lord, page 102.
102. Page 103 order has been affirmed by this order. 108 order.
108 order has been affirmed. The issue is, my lord, 18/3/23, our AGM was held. Then, my lord, somebody complained and the registered cancelled. My lord, I approached
What cancel? What?
My lord,
18/3/2023 AGM was held.
held, my lord.
Election was held.
Election was held. And my
AGM
lord,
election both.
my lord, and thereafter, somebody complained and the register cancelled that AGM. My lord, I approached the Honorable High Court.
But approval was accorded by on 13/9/2024.
24, that is page 58, your lordship will get.
Page 58. Approval was accorded.
In 13/9/2024. So legally, we got it from 13/9/2024. And my lord, on 16/9/24, the first BOD took place. Page 59. So my lord, under section 30, subsection 4, 15 days virtual notice has to be given. So we could not conduct the AGM by September 30th. And my lord, there was a writ appeal. The writ appeal judgment came in our favor. I have annexed that to my lord.
Writ appeal on what question?
My lord, that because somebody complained that, my lord, our AGM was not properly held, and ultimately the registrar cancelled it. Again, my lord, he upheld that order. Again, the High Court passed in our favor. The complainant came before this court in a division bench, page 44. Not 44, my lord, 84. This is division bench.
Where is the single bench judgment first?
My lord, single bench judgment is at page 64. My lord, it starts at page 36. 44, my lord. Your lordship will get it 44. 44.
Just a minute. First, page 103.
It is.
Just a minute. "44, you are saying?
44. Where we approached after the registrar upheld his original order of cancelling the AGM.
Now, first is, let me go slow. On 18/3/2023, election AGM was held, right? Then what is the immediate next event?
Somebody complained to the minister, and the registrar, on the basis of the complaint, cancelled my AGM.
Which is the order?
My lord, that order was challenged, and
Now, which is the order?
That order, my lord.
Page 38.
Page 38. My lord, that is at page, I think, my lord, peruse the complaint. That is page 31.
38.
20.
Many.
28.
So many events.
My lord, 28 you also will find it.
Come to page 31.
31 is because typed copy is on page
31.
31 is the original.
No type copy.
My lord, I understand. 31.
There is a complaint regarding AGM Meherpur. It is alleged bottom line. So voter list was full of anomalies, right? Page 31. So it was the AGM was held in violation of section Act 2007, and the AGM was disapproved, right?
Yeah.
Then that was challenged.
Challenged, and it was
That was challenged. Let us see, understand.
Page 36.
Page 36. That order has been challenged.
Well, challenged.
3rd of April. Then what is the operative part?
Page 37, para 6.
37, made set aside the order. In violation of principle of natural justice.
No.
Thus the petitions were not heard. Not dealt with the merit of the case. Okay. Then this order, page 38.
38.
On perusal of the so and so, it is found a merit of the same order.
Same order.
That is on 21/9/2023.
That was under
right?
challenge.
Then again challenged.
Page 40.
By you.
No. Page
Okay.
40.
Page 40.
4.
Page 44, the judgment starts.
Operative portion, my lord. Page 56, 57.
56, 57.
20, para 29, para page 57.
Para 56. Page
56, para 28.
Impugned order is set aside. Register order is set aside.
My lord,
Okay.
this judgment was passed on 31/8/24.
31/8/2024. Thereafter,
my lord, page 58, approval given of our AGM on 13/9/2024.
approval to the AGM on 13/9/2020. Okay. Yes, approval given.
My lord, then on next page, page 59, 16/9/24, our first board of directors meeting took place.
Okay.
Then, my lord, and our first meeting was approved at page 64.
Okay.
Then thereafter, my lord, we made a representation.
Any resolution in that meeting to hold the AGM?
My lord.
Any resolution?
In the meeting, my lord.
Yes. First meeting.
First meeting, my lord.
Nothing.
My lord, because thereafter, my lord, your lordship will find in the page 65.
17.
Meeting of the board of directors, 7/10/24. My lord, thereafter, we wrote a letter to the ARCS, page 72, your lordship will get it, to hold our AGM. Page 72. Then the ARCS write it to the register.
Just a minute. Okay, there is a resolution at page 65.
Well.
Okay, resolution. Then which letter?
Page 72.
72.
We have informed the ARCS and the ARCS write it to the register.
I have the honor to inform you that this office has received order of the Gauhati High Court and according on the basis of the order AGM held on 18/3 was approved. Is there a periodic proceeding of the sale of the submitted? Then I have requested for the whole AGM within 31st March. 2025.
My lord.
Since
Thereafter,
the
my lord, there was a
meeting held
retaping.
on so and so upon the said court order for which locality could not hold within September so and so due to time constraint. Okay, this letter is from ARCS to register.
Well,
Okay.
thereafter, my lord, there was a writ appeal against the learned single judge order.
Okay.
31/8.
Okay.
That is at page 80.
80. By the respondent.
Respondent. The judgment, date of judgment is, my lord, in February 26. My lord, that of 23/2/26. Page 84, your lordship has got it. Date of pronouncement of judgment 23/2/26.
Page 91.
Page 84, my lord, is the date of pronouncement of judgment. 84, that is 23 to 26. And page 98, the writ
No,
appeal.
just that something has come to my notice. Para 28.
Of my lord,
Page 91.
91. One.
Because page 64. Come to page 64.
Well,
Page 64, ARC has approved the board meeting,
well,
board proceeding,
well,
page 91.
well.
Just I lost the sequence of events. Okay, anyway. I look. Which is operative part?
Operative court, my lord, that writ appeal got dismissed.
Writ appeal got dismissed.
Page 98, para 66.
98. That they did not prefer an appeal. Regarding the voter list, the objectors did not prefer any appeal within 10 days time. So writ petition was dismissed. The said order has been affirmed.
Writ petition was allowed. Our writ petition was allowed.
Our writ petition was allowed. The impugn order was set aside.
Set aside, and the writ appeal preferred by the respondent got dismissed.
Meaning thereby, in the meantime, this on 2/9/2024, the proceeding of the BOD was approved. So let us see now.
Now at page 99.
99.
Was later written to us.
Comments. Then,
my lord, we, in pursuance to 99, we informed them through page 100 that because case court pending was there, cases were pending, 13/3/23 order was approved on 13/9/24. Then
13/3?
13/8/23 first general meeting order, election, first election of annual general meeting, 13/3. 18/3/23, madam. 18/3/23 got approved on 13/9/24.
13/9
to 13/9
or 23/9?
13/9. 13/9. That is at page 58.
So 13/9/2024, it was approved.
Approved, and my lord, our BOD took place on 16/9/24. So there was no 15 days gap to hold the annual general meeting.
Approved. And by which resolution you were supposed to?
My lord, page 65, there is another resolution taken, my lord, at 7/10/24.
1 minute. 18/3/2023 was approved on 13/9/2024. So thereafter, board held its first meeting
on, my lord, 16/9/24, page 59.
16/9/2024.
24.
Page
59.
59. Okay, that was approved again on
Page 64,
23/9.
23/9,
Then again meeting on 17th.
17,
Then decided to hold the AGM.
AGM.
And that was again approved,
Approved.
or what?
My lord. In the meantime, there was a writ appeal, my lord. Page 72, my lord, regarding holding of AGM. Page 72. Assistant Register, right to the register.
Submitted to this office. Yes, what is your submission now?
My lord, here there is no willful violation on my part in not conducting the AGM in 2024-25. And I want to conduct all the three elections of 24-25 and 25-26 before 30th September. So, and this order, my lord, the first order and thereafter the appellate order, both are without non-application of mine.
Appellate order is non-esteem law.
Non-esteem.
Because for the reason that page 103, he has exercised the power under section 41. Zonal joint register. That is a delegated power under the notification of the state government. Right?
My lord, I am.
So virtually, he has exercised the power of the register by this order. Now, by 1068 order, register cannot sit in appeal over his own order. Just because Zonal Joint Register has passed the order by virtue of delegated power. All these are jumbled up everywhere.
My lord, I am a student of cooperative society.
No, I am also trying to be a student of. But what I have learned, I have to unlearn.
This cooperative society.
Now I have to unlearn myself.
This code is an encyclopedia.
No. I am not saying that this, because everywhere I have seen. That is why I pointed out to page 91. Again, there page, everybody has page to para 28.
Well,
Para 28. Register jurisdiction to disapprove. AGM election is supervisory quasi-judicial in character. Well, once assistant register has approved it, he cannot sit in supervisory capacity again. But everybody is making observation left and right. I don't know, my understanding is wrong. But 108 is not, we have to examine only 103. 108 order is of no consequence. I can right now set it aside, 108, but 103 remains. Shall not proceed further. But we have to examine the issue. Yes.
You have to obtain instruction.
But it will not revive you, but if we set aside this order 103, you can get back into your position.
But my lord, something that
resolution part, we cannot, interim order shall not be the final order.
My lord, cannot be the final order. My lord,
But
only thing
this
that
man should continue, but there should not be
any election,
new BOT.
no new BOT, and no
Shall
new
not act further. This officer management shall not act further for constitution of new BOT.
My lord, that will do.
Let him continue.
My
But
lord.
if this order gets set aside,
My lord.
your body will be revived.
My lord, correct.
Otherwise, creation of new rights. Yes, madam. Sir.
But we'll obtain instruction in this.
Heard Mr. P.K. Roy Chaudhary, learned senior counsel, listed by Mr. H.I. Chaudhary, learned counsel for the petitioners. Mr.
K. Sodial. on behalf of-
K.A.
Sodial. Sodial.
Sodial, learned counsel
On behalf of
on behalf of
S.K. Talukdar.
S.K. Taludar, learned standing counsel. Cooperation Department for the respondent number 124. 1234. Where is 6, Mr. Roy Chaudhary?
6 is not in here, my lord, because this subsequent orders is not.
No, respondent number 6.
Respondent number.
In the area of respondents.
One man committee.
One man committee, my lord. Respondent number
6 missing as well.
Where?
5, 7. Where is 6?
And 7.
Hospital.
There is no
It should be 6.
respondent.
It should be-
Arrayed as respondent number 6 in this read petition. Where the petitioners, 14 in number, were members, were directors of who directors were elected into the board of directors of Messrs. Meherpur Krishnapur Cooperative Society Limited, comma, a registered society, registered cooperative society under the provisions of the Assam Cooperative Societies Act 2007, comma, in an annual general meeting stroke election held on 18/3/2023. First, a number of litigation ensued thereafter, and finally, comma, the proceedings of the AGM stroke election, comma, held on 18/3/2023, comma, were approved on 13/9/2024.
24. Page 58.
Full stop. The petitioners are aggrieved by an order dated 13/19/2026 within bracket Annex O, and a subsequent order passed by the respondent number 3 and another order passed by the respondent number 2 purportedly in an appeal under section 111 of the Act 2007. By the order dated 19/5/2026, the respondent number 3, in exercise of powers under section 41(6) of the 2006-7 Act, has appointed a senior inspector stroke auditor of cooperative societies, O, the assistant registrar of cooperative societies within bracket the respondent number 4, to manage the affairs of the society and to hold the AGM stroke election and constitute a new board of directors of the society within a period of 90 days as per the provisions of the 2007 Act. So by the impugn order, by the said impugn order, the board of directors of the society it was by the said impugn order, it has been observed that the board of directors of the society, elected pursuant to the AGM election held on 18/3/2023 and approved, the proceedings of which was approved on 13/9/2024, had failed to hold, stood automatically dissolved under Section 39 of the 2007 Act due to failure on its part to hold the AGM for the year 2024-2025 on within 39/2025. Full stop. The subsequent impugn order dated 22/06/2026 has approved the order dated 19/5/2026. Full stop. Para, Mr. Roy Choudhury, learned senior counsel appearing for the petitioners, has submitted that the proceedings of the AGM election, held on 18/3/2023, after protracted litigation, were approved only on 30/9/2024.
Page 50.
Full stop. After 13/9/2024,
Page 59.
Oh, no, got approved on 13/9/2024, not 30. 13/9, 13.
13.
Page 58. After 13/9/2024, the board held its first meeting on 16/9/2024. The proceedings of which were approved on 23/9/2024. Thereafter, the board held another meeting on 17/2024, wherein, by resolution number 3, the board decided to hold the AGM of the society within 31/3/2025 for the year
24 to 23.
2000, okay. 31/3/2025. Within. It was pursuant to when the meeting, minutes of the said meetings dated 7/10/2024 were forwarded to the respondent authorities in the cooperation department. The issue culminated in an impugn order dated 19/5/2026. Para. Mr. Roy Choudhury has further contended that as the order dated 19/5/2025 6 has been passed by the respondent number 3, a notification concern. A notification concern. Access a government notification. This issue is to be settled because everybody sits in appeal here.
But I understand.
This issue, everybody ignores that vital aspect.
During that aspect,
everybody sits in appeal over everywhere.
In the case of Bikrampur, this point was also raised. And it was
yes, but still everybody sits over everywhere.
That was a single page notification.
Yes, everybody sits everywhere, creating havoc everywhere.
And Bikrampur has decided some portions.
No, I said, but still everything is ignored. That was not discussed. Respondent number 3 has passed the order under section 41 within bracket 6 of the 2007 Act, in exercise of delegate powers delegated by the state government under section, এখনো নহয় কালি কিনাখন কেছ করলাম দেখো এক পেজৰ নোটিফিকেশন এখন আছে কিবাখনত গাথা আছে anyway under section 3 within bracket 2 of the 2007 act the order dated 22/6/2026 passed by the respond number 2 amounts to would privacy appears to be an order privacy appears to be an order which cannot be passed by the respondent number 2 as an appellate authority as for the reason that the respondent number 3 the order dated 19/5/2026 is an order passed by him only, though it has been passed by another authority under delegated powers. We just put it, we are not we are recording your submission. This is issue notice returnable on so-and-so, as so-and-so has appeared accepted. No formal notice, extra copies within 2 working days. Having regard to the projection made and the facts and circumstances obtained the case in hand, it is ordered in the interim that for balancing the equities, it is ordered in the interim that the direction made in the impugn orders dated 19/5/2026 within bracket annexer O and affirm in the impugn order dated 22/06/2026 within bracket annexer Q insofar as the holding of an election for constitution of a new board of directors by the officer on management shall is concerned shall remain in abeyance till the referendum.
Supplementary list, item 57.
Oh. Yes.
My lord, matter relates to eviction, my lord. My lord,
Evicted or not yet evicted?
my lord, going to be evicted shortly, my lord. That is the apprehension. my lord.
What is the notice? When is the
Not
notice?
the notice, my lord, maybe
16.
starts at page, my lord.
89.
89, my lord.
Vernacular page 90.
So Mr. Bhuya will be coming to the court tomorrow also. We can post it tomorrow. Motion.
My lord, my lord. But actually, we are the disturbed people in 1983 riots, my lord. Then
No,
government.
10:30 will examine tomorrow with a fresh mind.
My lord.
Air Bhuya, senior counsel for the petitioner, aforesaid revenue. One, revenue and Mr. H.K. Hazari for a state responser present. And due to possible time, the case could not be taken up today, is the case tomorrow. In a motion call.
Obliged.
Actually, one case took some time. Yes, Mr. Borthakur, I have been noticing that you were sitting here since a long time. I think these are the case.
My lord.
Series. Okay.
Item numbers 31 to 40 of today's.
Please, my lord.
Your lordship will remember that these were the cases.
Some income tax.
Income tax matters. Faceless notice and all that, my lord. My lord, there were two.
It is, everybody is ready to continue with the matter. We can post it on a hearing date immediately
Lordship, on the
with a fresh mind.
Yes.
My lord, I am representing item number 38.
My lords,
I am withdrawing.
You are?
I am withdrawing item number 38. my
Oh, you could have said at 10:30 instead of waiting at up to 4:30,
My lord,
4:45.
my lord, it was a group case, so I thought that others will also be appearing.
You could have informed
So,
the standing
can you
council, the
imagine-
income tax on at 10:30 itself.
My lord, with a liberty to file a fresh petition challenging the insertion of section 147 capital A, as well as the maintainability of notice under section 148. That is,
Challenging which provision?
147 capital A, that was inserted by the Finance Act 2026.
Okay, then it will be out of my purview. It will be before division bench. I can readily allow it. Yes, Mr.
Lordship, what is happening?
All contention will remain open for the parties to be agitated in the fresh petition. Because if virus has to be challenged,
Lordship, that's right.
legality of a particular provision, then this has to be challenged specifically,
My lord.
Yes.
not indirectly.
My lord, in fact,
I
my-
don't think in this writ petition that challenge is there.
No. Till date, my lord, no challenges has been made, my lord.
And I indicated in the previous date also.
Lordship.
on the
And in
previous-
fact, my lord, issue was there. It was before Supreme Court, my lord, and Supreme Court has remanded back to the respective high courts, my lord.
But in those petitions,
Lordship.
perhaps it was challenged.
My lord. No. That was not
It was not
my lord.
challenged, but
during
opportunity was granted
Yes.
for 1 month
Lordship.
to make amendment,
Yes, Lordship. Lordship.
right?
my lord.
If I remember correctly.
Lordship.
My lord, only in those cases where SLPs were pending before.
Only
the-
those cases.
Yes,
That
ma'am.
is why one of the writ petition was allowed. Sorry, that order
was
was recalled on the previous date.
Lordship,
Because
that was withdrawn.
that writ petition was part of the SLP. Thousands of SLP.
Lordship.
Yes,
Yes.
Right?
Yes, Lordship. Yes.
That's right.
L Gop was
Yes,
there.
yes, Lord.
Right.
That was,
So you want to withdraw it
I want to.
with the liberty to file a phrase.
Fresh petition challenging 147A as well as maintainability of section one,
Okay.
notice under section.
Yes, who is opposing this writ petition of Mr. Goenka?
Who is there?
Who is the counsel? From the income tax department?
Lordship, in that case, my lord.
Item 38.
I am the novelty taker, no?
No,
Yes.
Mr. Gogoi.
Yes, Lordship.
So we can allow
Yes.
all contentions are open to be agitated by both the parties
Lordship.
in the fresh writ petition,
Lordship.
so that you can raise the ground of constructive res judicata also, if it is sustainable.
Lordship.
Yes. So far as this petition item number
38.
is concerned, 38.
Lordship.
What about others?
My lord,
We can proceed with
By
others.
39 is also I'm appearing.
No, you are appearing is different thing. The case,
Regarding this.
the other seats.
In other cases, Lordship, otherwise pleadings are complete, my lord.
Good enough.
My lords,
Lordship. In fact, on the last occasion, in item number 31 and 32, my lord, the counsels for the petitioners have sought for liberty to
Are
file
you
the
there?
Lordship. So amendment that was not filed as of now. So my lord, your lordship may continue with the my lord the pleadings completed, my lord. So let it become
May-
a
may-
hearing,
may-
my lord.
Item
I think, I don't know. Just a minute, just a minute. Adi ki tarikh? Adi 20 tarikh. 23rd of 282, no? You reply, Dalmia. Kuntu ita. Oh, 28. 23. That is with the current papers. July, no? 21. 21 not way to gas company. Are we to key? Routing number. It was also Kiva. You reply 23. 23. We can proceed with the hearing if everybody agree. 3007-2026.
Lord. My lords. My lord.
Yes. Petitioner side.
My lords, I am appearing.
Yes.
40,
You are
serial
mute.
number 40. I just
The council who is in
unmuted it, my
the
lord.
virtual mode, you are mute.
My lords, I have
Unmute
started
yourself.
my I have started my audio, my lords.
Who is addressing? Huh? In which petition?
He's in item 40 on behalf
Item?
of Mr. RJ Das.
Item?
40 also, my lord, we filed our affidavit, my lord, on last Friday.
Arjeras is present,
He is appearing on behalf of Mr. RJ Das.
but I'm not hearing his voice.
I am the counsel on the matter.
Problem with the. He's appearing, but his voice is not coming. Anyway, 31 and 32 as they.
These two matters receive instruction to the client for filing the additional affidavit. In the meantime, we'll file it broadly.
Petitioners. Who is for 33 to 36? 37. I am
Lordship, 35.
petitioner.
I am the
Petitioner side.
I am the petitioner on behalf.
Mr.
P. Sharma.
P. Sharma, learned counsel for the petitioners. Go to the same. Khali arguing ka etu rakhi ho khali belake. SK Saha. SK Saha.
Lordship, I'm for item number 13.
SK Saha. WBC 5675.
Yes, ma'am.
And who is for RJ Das? RJ Das. RJ Das. Madam, your name?
Chandni Devi, C. Devi.
C. Devi, learned counsel for the petition. RJ Das or right? Other counsels are same in the previous order?
Lordship.
One S. Setia, you were there.
Lordship.
Dr. B.N. Gogoi.
Lordship.
S. Sankti. Sancheti. Oh, Sankti, no, Sancheti.
Item number 36, my lord, I have already filed the affidavit in opposition. 36.
And ML Gop. Miss.
Item number 33 and 34, Lordship. A. Basu, on behalf of ML Gopal. We have filed our affidavits in opposition.
ML Gop. Item number?
33 and 34, Lordship.
Okay, it will be difficult. Write down against each name the name of the council. Okay. You segregate the other one. Item number 38.
My lord, in item number 39, we have filed an IA to bring on like subsequent development that may be taken from next week.
In 39 also, Lordship, we have filed.
We'll put it on 37. Whatever pleading is there, it will come.
Lordship.
Okay. Heard Mr. R. Goenka, learned senior counsel, stated by Mr. U. S. Watergold, and counsel for the petitioner. Who is the counsel? Dr. B.N. Gogoi.
Lordship.
Learned standing counsel, income tax department for all the respondents.
Lordship.
Close to para. Mr. Goenka, learned senior counsel, paying for the petitioner, has submitted that the petitioner intends to challenge the legality and validity of section
147.
capital A of the Income Tax Act
1961,
comma, as substituted or inserted?
It was inserted.
As inserted.
Newly inserted.
And as inserted by Finance Act
2026,
comma, and any other?
And maintainability of notice issued under section 140.
And maintainability and maintainability of the notice
issued under section 148.
Under the provision by virtue of
under the provisions of section 148 of the Income Tax Act 1961.
Subsequent to such insertion of 147A. Close to para. Mr. Dr. B.N. Gogoi, learned standing counsel, Income Tax Department, has submitted that he has no objection if the writ petition is allowed to be drawn, with the liberty as sought for. However, it should be open to the respondents to hesitate all of the grounds in the subsequent writ petition if filed.
Lordship.
In view of the above submission made by the learned counsel for the parties, the writ petition is dismissed on withdrawal, with the liberty, as sought for. It is observed that all grounds would remain open for the parties to be hesitant in the subsequent writ petition, if filed. Okay?
My lords,
Just write the names, list the cases as sought for and agreed to by the learned counsel for the parties, list the cases on 37/2026, post of all pleadings submitted by the parties are to be brought on record.
my lords, may I mention?
Interim orders, wherever passed earlier, shall continue till the next date of listing. In the other order, in the other expedition, any interim order was there. So the interim order, see, if passed earlier, shall stands recalled in the B.N. Gogoi's case, item number 38. Okay, any the other petitions, whichever in the
My lords,
list,
am I audible now?
we'll just go by one. Mati, 41.
41. Item 41.
What is the case about?
Lordship, here the
Counters are filed or not filed?
no, not filed, my lord.
Mr.
has to file a counter affidavit.
Jay Singh, learned counsel for the petitioner, is present. As the respondents have not yet filed their respondent,
Respondent 2 to 5.
which authority?
GMC and GMD.
GMD authorities have not filed their counter affidavits. Let the case be listed after 2 weeks for filing of counter affidavits by the respondent GMC/GMD authorities. List the case on so. We'll give the date after that.
Yes.
10th August, 10/08.
Published.
Item 44. 44. Item 45.
Yes, madam, it is for what?
Acidita case, Lordship, and she
Okay.
has not received the interim 1 lakh.
Uh,
And medical board.
1 lakh it is not received.
Not received.
And other things are not there. Okay. D goes learned counsel for the petition is present, release the case on so and so. Immediately we need to sort it.
31st July, 3107.
Can it be on 30th, Lordship, if it's business? 30. 31st, I'll be out of station.
30 July is holiday. Sunday.
No.
Day after.
Thursday.
30 July is
Thursday.
Thursday, Lordship.
July.
July,
July.
Lordship.
Who needed this?
31st.
No, so not a case of Thursday. Oh. Are you, will
I'll
be out of station?
station.
Okay, then 3rd of August.
The-
Item 46.
Some time is required to file reply affidavit.
You filed affidavit.
Affidavit by the respondent number 3.
Mr. R. Sharma, learned counsel for the petitioner has sought for and is granted 3 weeks time to file a reply affidavit to the affidavit of which filed by
Yes.
which authority?
Co-district commissioner, Titawat.
Okay. Respond number 3. Mr. J. Hendrick, learned junior government advocate, for the respondent, state respondents is present. Please the case on so and so.
19th August, 1908. Item 48.
B. will score, petitioner present, yes.
We have received the instructions first.
Instructions awaited,
Receive, Lord.
received.
We'll be filing our affidavit.
When?
By 2 weeks.
2 weeks.
Lord.
Ms. P. Thapa, learned counsel on behalf of Mr. As Dr. Learned Standing Council Panchayat and Rural Development Department has submitted that necessary instructions to file the counter affidavit are received and has therefore sought for 2 weeks' time to file the counter affidavit. The prayer is allowed, is the case on.
12th August, 1208.
Okay.
Item number 50.
May I please, Your Lordship? Your Lordship, in this case, the disputed amount is 2,000 and remaining is account has been freezed because of this non-KYC. They have to complete the KYC only.
Okay, lays the case on. Mr.
Yeah, Malik.
M. Ali Malik,
Malik.
petitioner, and Mr. M. Sharma, respondent number 1 and 2 are present. List the case from as sought for.
20.
Aji Monday.
Aji Monday.
Monday. Okay, Monday. Friday.
24.
Yes. This Friday.
2407.
Yes.
Item 52.
Yes.
I mean, on behalf of NHADCL, 2 weeks time may be granted for filing affidavit.
Get the instruction. Basically, it is because you two not giving 60 days time. 60 days time. If you admit, I'll set aside the notice and permitting you to serve a fresh notice, providing 60 days time. That's all.
That's all. Nothing
Is it not?
Yes, that's 60 days.
On the face of it, it is not sustainable.
No.
So why filing the affidavit? If you admit that instead of 7 days, it should have been 60 days.
Yes.
I'll set aside the notice with liberty to the NHIDCL authorities or Kala to issue a fresh notice. That's all. If Mr. Borua admits, if you file an affidavit, the petitioner will file another reply affidavit and it will, instead of 60 days,
it will be
be
delayed.
6 years.
Yes. Yes, that's all.
No point filing
No
an
point. No
affidavit.
point. I understood. No point.
So we'll fix on next Monday?
Monday.
Huh?
But 60 days you will not complete.
No, Mr. Borua, we have to see the business of the court also.
Oh, yes, my lord. Lordship, as you seeing all this order is passing now. I have thought you have seen entire order.
Having seen Mr. Borua, everything comes into my mind like a cinema.
Even I'm
Like
not
a cinema,
proud. Lordship is
like a cinema, Dhurandhar. Mr. Borua, Learned Standing Council in IDCL has sought for listing of the case on next Monday.
27.
In the absence of the Learned Council for the petition to establish the case. Accordingly, on so and so, the interim order passed earlier shall continue till the next date of listing.
Supplementary list, item 60.
Be there on that day.
I'll be willing.
Item number 60.
Yes, affidavit filed.
You have filed affidavit?
They have filed affidavit.
Okay, we'll post it on some other day. J. Amit, Learned Council for the petition, and Mr. J. Hendrik, Learned Standing Council Revenue Department are present. Let the case come as sought for by the Learned Council for the parties be listed on the data video 10 দিনৰ মাজত পিছত
10th August, 1008. For orders, item 53.
There is some mistake in the cost title matter, but matter was disposed of matter.
Okay.
Item 53.
MS6.
May I please, Lordship? Lordship, here it is under process. The finance sanction is under process. Lordship, may kindly grant us 2 weeks more 2 weeks time.
No, what is this?
So, Lordship is a contractual bill.
Non-release of contractual dues, my lord, they have further submitted the fresh proposal.
53.
My lord.
Lordship.
Okay, Mr.
S.K.
Sharma is present. Learned Council for the petitioner is present. Mr. Learned Council has sought listing of the case after 2 weeks.
Lordship. Lordship.
In order to complete his instructions. Request made by so and so is accepted. List the case on so and so.
1208.
Next is
Item 54.
Yeah, 54. List the case on another day because it is 5 o'clock. Some other day.
Lordship.
As Setia, MS Sikh, petitioner, as Setia, standing counsel.
S. Kataki, Your Lordship.
Oh, sorry. Yes, Kotoki. ACI are present. List the case on so and so.
14th August, 1408. Item 55.
14, it's okay. Correction. Correction.
Correction.
Okay, I got did you. Before that,
7th
some
August,
other day.
0708.
7 hours. Obliged.
Item 55.
What is the case about?
Lordship, bank account freeze.
Bank has appeared.
Yes, Lordship.
Affidavit filed.
No, Lordship, we need some time, Lordship.
Okay, Mr.
M. Alam, Lordship.
M. Alam, learned counsel for the petition is present. Miss
H. Purva.
H. Burwa, learned counsel, has submitted that she has entered appearance on behalf of the respondent number 1 and 2. Full stop sound.
55.
Peruse the office note. Okay. As per office note dated 4/6/2026, comma notices upon the other respondents have already been delivered. First of, let the case be listed in the appropriate column on so and so after 2 weeks dated here. The respondent number 1 and 2 are to bring their stand by way of an affidavit on or before the returnable date.
1408.
Obliged.
Item 56.
But Lordship, in this item, we have filed wakalatnama. We will file affidavit in opposition. Kindly to.
Mr. A. Islam, learned counsel for the petition is present. Miss
R. Begum.
R. Begum, learned counsel, has submitted that she has entered appearance on behalf of the respondent number
8.
8 and has sought for and is granted. Miss Begum has also sought for and is granted. How much time?
2 weeks.
2 weeks time to file counter affidavit on behalf of the said respondent. Post up list the case after 2 weeks on a date to be fixed by the office. The other respondents are also to bring their stance through their affidavit on or before the return next date of listing. Any interim order?
Sorry,
Lordship,
Let us see. Silo, interim order absolutely extend করে দিও। No, it is until further orders. Until further orders, not required to be extended.